the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Justice Serve TV. We are live and on the air. And where are we? Well, this is Dedham, Massachusetts. And you can see the courthouse behind me there. This is the place where in just a matter of, about an hour, the latest Karen Reed hearing is going to take place. Today, the thing that is causing the court grave concerns will be decided. And that has to do with whether or not the defense had some connection with the ACA experts prior to the first trial, and obviously prior to the second trial coming up April 1st. Hello, Lindy Kenney Baden. How are you?
Well, good morning, Michel Bryant. I've been watching you set up with Justice Serve TV's Starlink. What an amazing piece of equipment that you're in the middle of a neighborhood, right, with the courthouse. Yeah. Where is the courthouse, by the way?
Well, we're in Dedham, and it's on the main drag.
Right. Behind you?
Yeah, it's right there behind me. It would be that thing.
The gold dome?
The gold dome, yeah.
Yeah, and it's a small courthouse. That's where Sacco and Vanzetti was tried, that same courtroom. We're going to, on Justice Serve TV, we are going to do an episode discussing Sacco and Vanzetti, a special episode, during the middle of all this, since we're going to be in that courtroom, or hopefully around that courtroom when the trial starts. So what's happening today?
Okay, so this is so important, mainly because the court is so concerned about it. Remember, let's go back to June 10th, 2024. This was during the trial, right? It wasn't before, it wasn't after. It was a hearing that took place during the trial when the defense was going to offer the testimony of the two it's ARCA, but with that Massachusetts accent, it comes out ACA. These two experts. And the court needed to be assured where these experts stood in the process, who hired them, who's paying them, who's been working with them. So the court asked the defense team, and Mr. David Yannetti is the guy who spoke for the team, even though Alan Jackson was there, as were the rest of the folks. And the questions were very simply, where do these folks come from? Where do these experts come from? Before we put them on the stand, I need to know this information. We'll learn, because there's about a 90-second clip of when that took place, what their position was at the time. And what causes the court concern now is the court has learned that there was maybe more connection between the defense and these, quote, independent experts than there really should have been, right?
Actually, the court said she had grave concerns.
Grave concerns.
And not just a concern, grave concerns.
Shaking, in fact, as she was announcing her plan, which was to delay the hearing from last week to this week. So before we get too deep into it, I think it's important. Let's take a look at, let me pull this up here. This again is the hearing from June 10, 2024. And this was again right in the middle of the first Karen Reed trial. Of course, she is accused in the death of her then boyfriend, John O'Keefe. And I'm going to find it here somewhere. I'm sure I am. I seem to have the same issue every time I look for video, right? And I'm going to see if I can find it here. Hold on. I do have it. I'm sure I have it here. What I want to find out, too, is, Linda, what are the possible remedies if, in fact, the court has these grave concerns? So what? I mean, what could happen, right?
Right. And not only that, not only what could happen, but why would she have the grave concerns? I mean, there's one thing to have a grave concern about an attorney, but there's another thing if you take drastic action against an attorney before a second trial, because the client has rights to a trial. The client has
Amendment rights for the counsel, all of that.
Right, all of that.
Okay, here we go. Let's listen to this again. This was from June 10, 2024. This is David Yannetti telling the court what, if any, connection the defense team had with the ACA experts.
Regarding the three experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Okay, so we're going to play that again and break it down.
Yeah.
But let's just talk broad strokes at the moment. We have representations from Yannetti that we didn't have any contact with these folks except to learn who they were and their scheduling availability. But there was nothing of substance. You heard him say it, Linda. So now the court is suggesting that was a lie to the court, suggesting that you did what's that?
It depends. Listen, when we listen to it again, what he was saying that we were told we couldn't have contact with him before the report, right? I'm thinking that there's a parsing of words there.
Well, there's definitely going to be. Whether or not it's legitimate or not, there's definitely going to be some fancy footwork here for the defense to get out from under what looks like this cloud of misdirection, misrepresentation. So let's listen to it again. Again, it's only 90 seconds. I'm going to stop it a couple of times.
Right. Yeah, let's
because
stop
there
it.
Regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor,
Okay, a couple of things happening here. The court, under Rule 14, has to be comfortable that the defense has provided what they need to the prosecution. It goes reciprocal. Either side has to do the same thing. And they've provided a summary of sorts. She's not sure that's enough, so she's asking for more from David Yannetti.
we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
Okay, these experts did not arise from us. That could be 100% true. 100% true.
Right.
It's more about what happened after they arose.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
You got that? They could not. It was specifically ruled they could not chat with us prior to trial.
Prior to the trial, prior to the report.
What was that?
Was it prior to trial or prior to the report? Prior to trial?
Prior to trial. I will back it up just to make sure you understand what she's saying here. And he's saying,
Pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So
before trial.
Can you play that again? Just
Yep.
one more little time at the very end.
Trial is the key word.
And it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to
Before
believe
trial.
that the
Did you hear that?
No, I don't hear the word trial. I'm having trouble with the word trial.
Wow. Okay. Well, I can't help you with that. It's about as clear as I could possibly imagine.
Yeah.
It's definitely before trial. What other
shout
word?
out, shout out
could
to a
even
new member,
work
by
in
the
that
way.
context?
Shout out
What's
to
that?
a new member making account.
Great.
All right. So it was specifically ruled they could not have contact with us or chat. You say it's prior to trial.
I think he might
believe
even
you.
say check with us. I think that's the
check with us,
CH
not
word.
chat, or check with us prior to chat. Okay. All right.
Prior
It
to
goes to
trial.
show you. It goes to show you how different people hear different things, and when you have a transcript, you say, "Oh yeah, that's the word. That's the word."
And to that point, the judge has required that the counsel for the defense, share with the prosecution and bring today to this hearing a transcript of this 90-some seconds we've been listening to. Okay, let's continue here.
Yeah, everyone agrees with you that it said trial. Sue said
Everybody
it said
says, okay,
trial.
all right.
defense is calling 3 witnesses that you've never spoken to and putting them on the stand here when
Okay, 3 witnesses you've never spoken to. Now, Maybe they had emails. Is that spoken to? I think you have to assume that spoken to in this context from the judge means contact of some sort that goes beyond what's your name, rank and serial number. What do you think?
Well, it's spoken to in terms of maybe the substance of the report. I'm not sure it means in terms of how you get to the courthouse, whether your fees are going to be paid to get there, whether travel is going to be paid. I'm not sure it means that. I'm not sure she asked the right questions, because I remember the defense turned over this. We're in this situation because they turned it over. So if they thought they did anything wrong, I don't think they would have turned this over.
That's possible. Let's hear what Yannetti says to this follow-up from the judge.
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Okay, coordination of their testimony and their background. That is pretty clear. There is no suggestion in that response that they spoke about the substance of the report or how it may or may not help the defense. Would you agree with that?
Right. But I agree with that. But the question is going to be, what did he say? Spoken to with regard to the, go backwards. Go back a second.
Hold on.
Coordination of their testimony.
Yes, hold on. Here we go.
And
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Okay. So this coordination of testimony, what does that mean? Does that mean did they charge a fee? Does that mean that somebody gets reimbursed? Does that mean that
or is that just scheduling?
Or is that just
scheduling?
Just coordination of testimony.
I guarantee you, these are the words they're going to be mincing up. Okay, let's continue.
We have not been able to interview them regarding their findings, which are
we have not been able to interview them regarding their findings. Now, that's substantive.
Right. And I believe I believe that's going to be the situation. That's going to come down. They weren't able to interview them regarding their findings, but they were able to interview regarding coordination of their testimony. So what does that mean? This is where it all comes a little hazy, right?
I think you can argue either way, but my gut tells me you're just past the 50-50 line in terms of being a little bit vague, and maybe purposely so that if you get caught down the road, you can make these arguments. I think he is close to unequivocal about talking to them about substance.
Or what we're talking about with that 24,000, it's a little under 24,000 billing issue occurred after Mr. Yannetti talks to the court. What is it? What was the date of this hearing here that we have?
This was June 10, right in the middle of trial, June 10 last year.
Okay, and I have to do a calendar as to when the experts, and our chat can do this, when the ACR experts testified. And the question is going to be then, when were the emails and the billing? Is it between June 10th and when they testified?
Yeah, it definitely soon after this, because they did a voir dire of those experts, and that took place before they testified. So it was in pretty rapid succession. Let's continue on here, see what else we can get out of this.
In detail in the reports that both sides have.
see, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to. And you have not complied with your Rule 14 obligations.
We can't, Your Honor.
Okay, he's saying we can't give the prosecution certain details we might need to under Rule 14 because they're not our experts.
Well, I'm not sure.
We've only had this limited contact with them.
Yeah, but they're not there are going to be our experts, but they were hired by somebody else, and the federal government refuses to allow us to interview them or talk to them regarding their specific reports before they testify. So, I think it's they're not our experts, or they're hired by the government, and there's a prohibition for us talking to them. Yeah,
I mean, I think to say they are not defense experts means they were not hired by the defense. Certainly the defense is using them. They are defense experts in that context, but not, hey, here's a check as a normal expert might be hired. Remember, this was a huge issue in that first trial because all of the excitement for the defense was, hey, this is just manna from heaven. These are experts we didn't hire, we got nothing to do with, and they're testifying in a way that totally supports our defense of Karen Reed.
Yeah, okay. But they were hired by, let's stop here because this is going to be important. They were hired by the government, by the FBI and the channel. If they were hired by the FBI and they come to their conclusions for the FBI, then anyone, I'm sure if the conclusions were the other way, then the prosecution would have co-opted them. So I think it's important that when they give the report, who's they're hired by. Afterwards, if they're paid to come to court to testify for their time, I don't have a problem with that. I mean, I don't know what her grave concern is. Now,
Yeah,
this
we
stuff be
don't know
turned
enough.
over? Yeah.
Yeah, I mean, there's still tons of blanks here. We're just setting the stage for what's
Right,
about to
right.
happen in 45 minutes in this
And
courthouse.
I'm asking the questions and doing some of the answers I think that we're going to hear in court.
And we should point out that investigation, it'll be announced in this courtroom in just an hour or less, has been ended. And that was the federal investigation into whether or not there was some sort of conspiracy within the Canton Police Department to set up Karen Reed. Nobody's being charged. The investigation is over, and that'll be announced later this morning here.
Yeah. And as we go on, Emily C. has a question for us, Michael. It's a very good one. Why is the alleged discovery violation a grave concern when it's the defense, yet everything seems to be glossed over when it's the state? I agree with you. And that's what happens in most defense prosecution cases. What we saw in a couple of the recent cases, and that was ASAP Rocky and all, that was like a different situation. That's like, we're like, wow. But in most cases, when the defense does something, it's always a problem. It's a grave concern. There's a violation. There's sanctions. But when the prosecution does something, it's like, oh, it's okay. So
it does seem that way at times. There is no doubt about it. I think what we see play out in this courtroom today will give us an indication if things are truly being evenly handled here.
We can't. So you can't, but you haven't. So I am left with you haven't complied.
Okay, now what she's just saying is, okay, I understand you think you're handcuffed here because it's not your expert, so you can't get the information you might normally provide under Rule 14. But I don't care. From the court's perspective, you haven't done it. I don't care if you can or can't. It hasn't been done.
So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Okay, and so that's the upshot. They brought them in for voir dire. They went through all of the issues, and the court limited the testimony of those experts. But it was certainly the stuff that the defense wanted to come in did come in.
So, Michael, I think now that we've talked about it, we should play that whole tape once more, all the way through. I won't say a word. You won't say a word. And let's see what our chatters think.
Okay, here we go.
Regarding the three experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling three witnesses that you've never spoken to and putting them on the stand here
that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for a voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
All right. I think it's going to come down to that reference to coordination, whatever that means.
Well, that's a problem, isn't it? It wasn't specific.
No, it's a lot of, but is it vague because they didn't know more, or was it purposely vague because they didn't want to disclose more? That's what we're going to find out today.
Yeah, but Arca testified at the first trial, right? And
Yeah.
so what are the dates of these emails? What are the dates of this alleged bill? Who's the bill to? What's it for? I mean, that's going to be an issue. If the defense provided it, that seems to be a compliance. I mean, the first thing I'm going to say, Your Honor, Mr. Brennan indicated, and he's a special prosecutor, as we know, try to indicate to the court that this was, oh my gosh, here, the prosecution, we're giving it to the court. And then later on, he kind of backtracks and said, well, the defense provided it in their emails and stuff like that. So I'm a little concerned with that, and that the judge may have taken the bait there.
Now, that's interesting. I don't think the issue is going to be whether they testify or not. I think the issue, I don't think, is whether or not there was compliance, because the court suggested that, yeah, your hands were tied because you didn't have the contact with these experts that you might with a normal expert. But I think the court's biggest concern is going to be this statement we just heard from David Yannetti, very specifically talking about the disconnect between the defense and these experts. And if she construes that in a way that is most damaging to the defense, then the question is, what's the remedy?
Yeah.
If you try to remove one of the attorneys, I think you got a problem. You mentioned it before. It's a Sixth Amendment problem.
And especially if you're trying to remove Alan Jackson, because the representations here are made by Yannetti, not Alan
True.
Jackson.
And obviously he binds the whole team. That we know, but you're right, because Yannetti's the only Massachusetts attorney. Everybody else is appearing pro hac vice from across the country, right? Jackson from LA. And so it would be so, I think it's an immediate appealable issue, and a pretty good one, if you remove one of the key attorneys from the defense team, a month-ish before trial.
Yeah, and Idiot Win, thank you for your donation to Justice Serve TV. That was clearly
nice,
before the voir dire. HB's Hank Brennan said that in the email, Wolf praised Jackson's questioning. So the email was clearly after the hearing and after these representations. That is a great pickup if you're praising Jackson's questioning. And remember, the federal government contract, as our chat has pointed out, ran out. It ran out. They did their work. They came to the report. Perhaps the federal investigation had ended into Karen Reed, and therefore they were finished. And then somebody would have to pick them up to get them coordinated to get to Canton and to testify. So that's another issue.
Yeah, I mean, there's a lot of questions that we hope to have answers for as this matter gets underway in about 40 minutes, give or take.
Yeah,
there's also some other stuff.
Right? We're actually.
Yeah, we'll be streaming it for the folks here, so you can just stick around here, and then we'll come back on afterwards and give us our thoughts on what we think happened. I don't expect any ruling from the bench. It could happen later today, but I would be surprised if the judge rules from the bench at the end of the hearing. But we'll come back on, share our thoughts and analysis on what we saw happen, and kind of predict what might be happening going forward.
Or she may. I mean, she may.
She could.
This is such an important one that even to delay for 3 or 4 hours, I think is terrible. I mean, she's going to know what she's going to want to do pretty soon, and I'm sure she has talked to other judges. Because what is she going to do? Revoke Alan Jackson's pro hoc? He didn't make any representations. He put the witnesses on the stand.
Yeah. And that's where it's interesting, too, because even though Yannetti is effectively speaking for the team, when it comes to pro hoc vice approval, and that's really just permission of the local court to allow an out-of-stater to practice, it's very individual and very specific. So I don't know that Yannetti's statements, even if binding the team per se, would trickle down to individual responsibility for Alan Jackson.
Yeah, and then the question becomes, and one of our chatters points out, could there be an ethical issue if there was an agreement for payment before the trial, if the defense paid expenses and didn't disclose it? Yeah, there could be, maybe, possibly. I mean, there's a lot of factual issues with regard to that. When they were coming there, did ARCA say, look, we can't provide our people to come unless we're paid for the expenses for them to come in the time for being away from work? We don't know, okay? But Idiot Win, who's really on this, and thank you again for your donation. Further, if we rewatch voir dire, Wolf mentions the same points about light and darkness that is discussed in an email. So that was disclosed already. Good, another good pickup.
Yeah, that voir dire was pretty extensive as well. And I'm curious to see if the second time around, and again, I believe they will be allowed to testify. I don't think that's ultimately going to be a decision that we come to today. It's going to be more the impact on the defense team. But are they going to be able to elaborate on what they testified to before, or are they going to be further restricted? Because the judge can make some tweaking on that.
Yeah, I assume it depends on whether there's supplemental reports, but I doubt that now there'd be supplemental reports. I think they're going to testify exactly as they did in the first trial, right? because then Jackson can say, you weren't paid by us to make that. You came to your decision here under the federal government, hired by the FBI.
And that, of course, that issue will come up on cross-examination of the witnesses, unless the defense decides to at least address it head on and head the cross-examination off at the pass, right? So yes, we had some interaction, right? And you charge for your time after the fact, and that would have to be what we're looking for. Was that time spent charged after the June 10 representation? That's really all that matters.
And was it paid?
Yeah, of course.
I mean, people can submit a bill all they want, but if it's not paid, so what?
Yeah, that would be very interesting to hear the backstory on that. If the defense position is, we never agreed to pay them. Well, I don't know why we got an invoice. I don't know what's going on. That would be an interesting position.
Wouldn't that be fun? I mean, you know that Alan Jackson, when he turns over this and that team, I'm not going to accuse anybody of unethical conduct here. Let's go see what when Judge Bev gets into court. I mean, she kind of created that. She didn't give Alan Jackson a chance even that day to explain, right? She had, I've been informed of grave concerns. Well, he said we provided those. He got up and said we provided those. The next question is to be, okay, what? Tell me about it. Right there, it could have been resolved right there.
Yeah, you're right. And she was so shaken, though. It was just the physical manifestation of her concern just seemed excessive. And that's why she cut things off immediately and called everybody back today. So obviously, after a week's reflection, I'm sure she'll have a more steady hand on the rudder. We'll see how this is going to unfold.
Yeah, I mean, grave concerns. When she said it, I thought there was something more, quite frankly, because the state gives Brady violations all the time, right? People get convicted to go to the death penalty with Brady violations, and no one seems to worry about that. No one has grave concerns about those, including in Massachusetts, right? But all of a sudden now we have grave concerns on this case. That's he's weighing in. He wants to come in.
Yeah, I'd say there are lots of places along this trial path that would lead to grave concerns. I'm not, at this point, I'm not sure where this one falls.
Yeah, I don't know either. When you're there because the courthouse was completely packed, you decided to stand away so we could do our show and have the courthouse in the background. I know that after we watch this hearing, you're going to go to the courthouse to try to get some interviews at Michael. But any word on who was there?
No, I have not seen the arrivals. The normal folks are gathered out front. I've come to recognize most of them now. They have all of their usual signage. I do want to take a quick look over there and chat with them about the hearing today could go against the defense, and it's such a strong defense presence outside the courthouse. I'm just curious to get their take on a scenario that could impact their team, as it were.
Right.
So
that's why you're in.
Why don't we do this? Let's see if I'm just calling an audible here. I know we have I think it's about a 13-minute recitation of Mr. Brennan when this issue came to light last week. If we can run that, I may dash over and just sniff around a little bit, and then come back here in like 15 minutes. If I'm not here, hang tight. I will come back. So let's do that. Missy, you have that handy? Can you throw that up there? If so, I will.
And if the court starts before this finishes, we'll go right into court streaming.
Okay, I'll be back.
Missy, you can take me off the stage while this runs.
An expert. Or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
All right, please.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, Would you be kind enough to call over there or check with whomever you were dealing with to see if I can, in fact, get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
Well, there you have it. Yeah, I'm a little concerned, as all you are, that Mr. Brennan did say something to the effect of, "Oh, I misspoke," or something. The defense provided the email. So it seems to me now that the court had nothing more when she went back into chambers but what had been put on the record. And what it was, as somebody pointed out, I think it was Idiot Wynn pointed out, that these conversations the defense had were after the voir dire, and it really had to do with the technical outline and all. Now, should you have turned it over? That's going to be the question that the judge is going to have to answer, to whether or not these are materials that the government could use, the state, Mr. Brennan could use, the special prosecutor, to cross-examine the ARCA experts. I think the court's going to say they should have been turned over before they testified at trial, since this was after the voir dire. But the substance of them was innocuous, in my opinion. I mean, I misspoke about how many times I testified at trial. Do you want me to correct it? Because he testified more, not less, right? I think he said once, and he said he had depositions and all that type of stuff. And then he said to Alan Jackson that his questions were great, indicating that it was Alan Jackson who had written the questions. He said, "I am an expert in human and lighting factors. I don't know if you want me to say that or not." Then Brennan adds in, "Yeah, that would be helpful. Thanks." I'm not sure if that was Brennan's comment on what the ARCA expert was saying, Mr. Wolf, or whether that was Alan Jackson or someone from the team's comment. I think that may have been a little bit of snark, just the way he said it, because he didn't attribute it to Alan Jackson. He didn't say Alan Jackson, then came back and said, right? That would be nice. I think that clearly came from Brennan as a snarky comment. So we're going to have to see what that was. This is all going to have to be broken out by Judge Bevan. She's going to have to make a determination. What if she makes a determination that there's a discovery violation for the defense? Well, she's made a determination that there's a discovery violation for the state. What's the remedy? The remedy is they have the materials now. There was a hung jury. They're going to get to cross-examine these experts now on these materials. So there's really no harm, no foul, because you're not going to go back and you're not going to go undo. And quite frankly, remember the reports from their own the state's medical examiners, there were 2 of them, and then the ARCA people said that there's no indication that the officer had been John O'Keefe had been hit by a car, hit by an SUV that causes death. To me, that's the main issue. If you can't say that the SUV that Karen Reed was driving hit him and caused his death, I don't think you can get a conviction for those top two counts, which the first jury, by the way, has said they decided that she was not guilty, but they weren't asked that. The courts now, including the head court, what would be called our Supreme Court, but the head court of Massachusetts said, no, sorry, she goes back to trial on those counts. Remember when we heard in ASAP Rocky, the judge asked or told them during their jury charges that if they have a verdict on one count but can't reach a verdict on another, they should tell the court. In almost every state that I have been involved with, that's in the jury charges, but it wasn't in the jury charges here. But that problem is now aside. Touche asked, touche, well, that's a touche, that's great. Do you think Judge Bev would have been so worked up if Brennan didn't misspeak about who sent the emails? Yeah, I mean, that's an interesting question, because if you want to talk about misleading the court, it sounded like he filed these TUI requests with the federal government, which is the way they have to get information from the federal government. And that, he finally got them after being denied. And there's all the stuff. And then he says afterwards, I misspoke. They were all given to me by the defense. Okay. So, I mean, if you're talking about everyone posturing here and everyone kind of posturing to get their spin, as if we're in a spin room in news media. Yeah, you had that right here, in my opinion. Okay. Now, so yes, these are all fabulous, fabulous, fabulous questions. Brooklyn says, is Alan Jackson going to show up or just on Zoom? Well, he said that he wanted to be there in person. I was looking at Twitter. I didn't see his arrival, but that doesn't mean that Twitter, people covering the trial, because as you know, you don't hashtag anymore when you do X, and you can, but they don't necessarily pull up everything that used to be so easy to do. You'd hashtag, you'd see everything. I saw Hank Brennan arrival into court, though. That is, somebody did photograph Hank Brennan arrival into court. Afton asks, is there an ethical issue if there was an agreement for payment before trial and if the defense paid expenses and then disclosed it? Could be. It depends on if it's just payment for expenses. So what? Okay. So what? But generally, you do turn that over, that you're saying you're paying for expenses. But who's getting rich on payment for expenses? Nobody. Who's changing the testimony on payment for expenses? Nobody. If you want me to come to California to testify, or if you want me to go to Massachusetts to testify as an expert, I'm going to charge you expenses. I'm not going to be out of pocket. As a matter of fact, if I don't charge you expenses, here's the interesting issue I'd make. If I don't charge you expenses, right, then I do have a bias. Because what I'm saying here, I'm giving you this for free, even though I'm no longer employed by the FBI, the ARC experts by the FBI, right, through their contract. That to me shows a bias. It's the charging for the travel that doesn't show the bias, right? It's the charging that you would do for anybody that doesn't show the bias. If you're working and you go out on a job, what do? You fill in your whatever percentage per mile you now get for your car, which is still not very much. And you fill in, and if you're still working and you're out there on time, you get paid for that. But if you don't, then you're just volunteering. That shows a bias. If I volunteer for an animal rights organization that says don't kill animals, don't eat animals, animals are not to be eating, that shows a bias of me against somebody that may testify, right? Who may not be a vegan. I mean, I'm drawing like extreme comparisons here, but to me, that you have to charge for expenses. If you don't, that could be a virus. And as I said, Idiot Wood had previously mentioned this, and I think that's good. This was all after the voir dire, So Michel Bryant is at there. I understand he is looking around. Now, remember, that courtroom is extremely small. It houses virtually no one because it was the courtroom historically that Sacco and Vanzetti were tried at. So here he is. He went back to the courthouse. He is now back. Michel Bryant, when you get back, we just had a really interesting question, and here was my answer. That this is if you charge for expenses and don't disclose it, is that a violation? I think if you don't charge for expenses and get paid for expenses, that's a bias, because that means you're donating something to the defense that you wouldn't ordinarily donate. and you're doing that to be able to testify so that you can be brought there. I think that the charging for expenses eradicates that bias issue, but that's just an argument that I would make if I were in the courtroom.
Yeah, that's an argument. Yep, that's an argument. You could suggest that, hey, we're doing this for free because we're on your side and we don't care about getting paid for it. We're on your team in a way that is more important than money. So
right.
I could see that. It's a good argument.
So what's happening out there?
Oh, it's crazy as usual. There are some new signs. I shot a little video. I will post that to our members, which shows some very creative signage, especially when it came to Judge Bev's grave concerns. The guy did a sign with some tombstones, and they go all out here. I did not sense, and those I spoke to did not suggest to me that there's any concern from the defense standpoint as to what's going to happen today. They understand the technical nature of what's going on. I think a lot of them understand Rule 14 better than I do, and I think their full support has not changed. All the parties have arrived, by the way. I'm sure those, if you're watching a Raw stream somewhere, they probably are in their places.
Is Alan Jackson there? Someone asked whether he's on Zoom. He said he wanted to be there.
Yeah. Remember, he had an issue with Zoom, and then he was going to move some things around. I did not see his arrival, so I don't know for sure. But Karen Reed definitely is in with the rest of her team.
Yeah, and we're monitoring that courtroom, by the way, so we'll go to that feed. Patrick Taylor. By the way, Patrick, thank you for that great breakdown today. We did get your email and do want to get more information from you because we did look it up and we know that you were not guilty on your second trial and you had a great attorney who's still alive. We'd like to get some more information. If you could send us some more about the rulings that there was on the reversal, if they have it, and talk to your attorney about whether the two of you would like to come on the air one day to talk about your case when we do a wrongful conviction episode. So you have our email address. Thank you so much, Patrick.
Yes, that was great. What a crazy story, right?
Yeah, Patrick, by the way, was wrongfully convicted of his parents' murder. Okay, and he sat in jail for 7 or 8 years. Then he was brought back to the local jail, and he was retried, and he was found not guilty of the murders. He was somebody wrongfully convicted. So he has a great story to tell.
So a lot of cops, as usual, out in front of the operation there, and it's so funny that it's almost like a barbecue environment. It sounds weird, but everybody knows one another. It's just this shared experience, for better or worse. I saw some new big signage on a car that was around the corner, like a car-sized sign that just said "Free Karen Reed." Which is interesting because she's not incarcerated. But anyway, put that aside. I think we know their sentiment. So what we expect is going to happen is there's more than one thing on the calendar today for this case. Obviously, this is the key, this issue with whether or not the defense had some connection to the ARCA experts prior to the first trial and what that's going to do to impact the second trial coming up on April Fool's Day. But they do have some other discovery matters that they're trying to squeeze in. Remember, the judge has been very insistent on keeping a very tight schedule as we roll toward that April 1st new trial date. And the dates have been massaged a little bit here and there. But what's the big one coming up? It's fully throated. I'll tell you that much.
Motion for dismissal filed by Alan Jackson, fully throated next Tuesday, I believe it is, right?
It is,
March 5th,
it is.
Right.
It's going to be.
And you're going to be there for that.
We'll just call it, Tuesdays at Dedham. That'll be on the Justice Serve TV docket. Every Tuesday we'll be here.
Just so you know, Happy Annie donated $5 here to Justice Serve TV. If it's true the first are done, the first testimony from ARCA, can the defense hire ARCA and now give them proper discovery? Well, they could hire them if for supplemental reports. They can't really hire them for redoing their
retroactively, right?
Yeah, because you don't want to do that because you want them to still have that independence. But yeah, I don't think there's any prohibition about them hiring if they wanted supplemental reports at this point.
Yeah. And, depending on what they're allowed to do this second trial, who knows? Who knows what they might do with these folks? Obviously, the only thing that they're really good for, and it's a good thing if you're on the defense, is that the experts will testify that the subject's Lexus SUV never bumped into John O'Keefe. I was watching some of, because it happened on the same day, June 10th, I was watching some of the Proctor testimony, and it was the point at which he was unbagging all of the pieces of the tail light. And I remember thinking the exact same thing last night as I remembered the first time. I said, how hard do you have to run into somebody to shatter a taillight into 15 pieces or more? I mean, the backup part of the light is the clear part of the lens. That was in 7 pieces. I couldn't do that with a hammer. So
Right, you
I just
tried.
think it strains logic to think that it was that contact, if it happened, that caused that kind of shattering. I mean, I just don't know how fast you'd have to be going and what part of a human body you'd have to hit to break that light into so many pieces.
By the way, Alan Jackson did arrive here. I was Karen Reed. Disney has the post Disney. Maybe we could retweet that under Justice Serve TV. I think you may have already done that. I have it. Oh my gosh. He told us he would do this for her, but I'm going to interrupt. Breaking news. Breaking news. Camp Shorty is Joe Tacopino is going to Camp Shorty. Lisa Shorty, he said he would do that for us, do that for you if you asked. We asked him last Saturday after the trial, telling him about your little thing that you gave us. And I am so glad that he is making that appearance. You will have a great time. He's a great interviewee, and he will hold nothing back. And I'm sure neither will Camp Shorty people. I have to break that. This is on ASAP Rocky. Lisa, it's Miss Shorty's from the OCs. They loved ASAP Rocky. They were following our trials. They're following this trial. They love Joe Tacopino. We asked Lisa to do a question for him, and we had Joe Tacopino's first breaking interview before anybody, before TMZ, before anybody, before he did anything last Sunday. And she asked him a question, and they have been big supporters of ASAP Rocky and Joe Tacopino. So I am so happy for you. It's Miss Shorty.
Yep. Good luck. It'll be fun. And yeah, I think you guys will get along.
To say the least.
Yes.
All right. So are the people making loud noises out there, screaming, yelling?
Yeah, it's the usual welcoming committee. And I sent these videos out last time to the members. When Brennan arrives, when some of the prosecution team arrives, it's cat calls. It's just yelling at them about things in their past. Like Brennan, it's how's Whitey Bulger? I mean, it's just odd. And then when anybody from the defense team comes along, it's cheers and free Karen Reed. And yeah, it could not be more partisan. I'll tell you that.
Yeah. Any indication of when this is going to start now? It's almost 11 o'clock. We know that all the parties are there. Initially, it was going to be about text. Oh, I'm sorry. I am being like, Lisa Shorty. Lisa, you're going to have to start doing Karen Reed for me because Joe Tacopino bought 4 Mr. Flexpack items for the merchandise store.
Oh,
Lisa, nice. All right, let's hope we have the same effect here on Karen Reed. We're going to try to own this story just like we did the ASAP Rocky story with Mr. Tacopino and everyone else with that great not guilty verdict. When the courts work well, when the judge has control of the attorneys, everything works well. And when the attorneys are great for their clients and honest and ethical, they should prevail and come out on top. So good job. Any other thoughts? A police car just went by.
I know they're circling around me here. I'm not sure if it's if I'm violating some local ordinance. I have no idea. We'll find out. Then I can see what it's like inside the Dedham Police Department. So
I'm gonna have to bail you out from here.
Yeah. One of the key finds from last time here was the building right across from the courthouse is I think it's like the public library or something. It's they have a tremendous bathroom there, so that's a key find anytime you're on the road. So what I'm going to try and do as we get
Michael,
ready to
before you do that, there is, in terms of New York, there's a woman who started the "You Have to Go" on Twitter. And she
rates like a map of bathrooms.
Yeah, well, she goes to every bathroom that you can go publicly and finds hidden bathrooms that are bathrooms for the public. They should do the same thing in Canton.
Yeah, that could be. I could work on that. I remember when George Costanza in Seinfeld, he had you could name a bathroom or you could name a location. He would say Macy's bathroom, 5th floor. He had his own Rolodex. But yeah, maybe that's another project I'll work on here. Dedham restrooms. Thanks for the plan on that. So I'm gonna.
Well, if this goes badly, you have another career.
That's right. I'm going to try and relocate. And when we come back after the hearing, I'm going to try and I'm testing a lot of our gear, obviously, but I've not yet tested the totally portable, because right now the Starlink is plugged into the car and I'm about 50 feet away. But we have a totally portable setup where in theory I could be, like walking around holding the Starlink. Not practical, but I may just on foot gather all my crap and wander over like across from the courthouse where I can't get the car. No, I can't get anywhere near there. But I'll just take all my stuff and plop down there. It could be interesting.
Yeah. Did we buy? And you can tell our viewers. Did we buy the battery packs that go with it, or did you have it on that?
No, I bought one and we've not used it yet.
Okay.
I used it at home, but I've not used it in the field. So it allows.
Well, we're ahead of the game. Yeah, we're ahead of the game. I mean, I read that we had bought ours, and then I read when the networks were all going to the California wildfires, all of a sudden they were starting to buy Starlinks. Maybe because we kept mentioning it.
Yeah, right. Yeah, we got a sponsorship with the Starlink.
No, we don't.
Okay.
I don't think Elon Musk needs any sponsorship right now from anybody.
All right. So I can't tell from my monitors here. Is the feed up yet? Are they poised? Where are we in the process?
No, we just have a screen. There is what you see. We just have the freeze.
Okay.
We're gonna be bringing in the camera that's covering it in the courtroom. We're gonna be bringing it into our feed. So we're still waiting.
Something else they might cover today. It depends on how loose the judge is with the proceeding itself. But remember, there was a partial decision that came down. We talked about it last night, based on what did get presented last week before the abrupt end to that hearing. And one of the things that's been floating around is this pro hac vice application by yet another attorney for Karen Reed. He's actually also Aiden Turtleboy's attorney, right?
Mark Betteroy. Let's go. I think we should. I know we have.
Fan.
We have spinning fan, and we have audio, so I think we should listen. Mark Betteroy was initially denied, but he has to provide more documents.
Yes, that's right. At this point, he's been denied. So we'll see if they may address that today too.
Yeah.
So
let's see if we can listen. Oh, there's sound, but no video. Here we go.
You are unmuted.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lauer for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Dinetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There's another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
Thank you.
Here's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what, actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
You are muted.
Well, okay, we have a 5-minute break. Let's go on. I was trying to write as fast as I could. Shout out to the court reporter there, by the way. She is the same court reporter who's been in Hernandez that we had her. She's great. You see her with her mask, that she speaks exactly what everyone says in the courtroom. Like, she's got it over her, and she can hear in one ear, and then it comes out what she's hearing speaking. It's just an amazing, amazing thing. So, okay. So here's what Judge Beverly Cannone said. She starts out by saying that she's here because after the last hearing, she had these concerns. And she did not think, number one, she had 3 reasons, that it was fair for the defense to answer her concerns. But what gave her concern, she said, was something that we haven't heard. And that was number 2. And she actually phrased these, number 1, number 2. She said there's a transcript of the sidebar. I think she said February 6th. You can correct me if I'm wrong, right? Where Judge Cannone asked about what people have from the federal government. And she said something to the effect of, you have nothing more than what the state has. And she said something that, Mr. Jackson, you did not disabuse me of that information. Now, there's a transcript of this that she just had marked and given to the defense. I believe it was just marked now. So she's given the defense 5 minutes to review it, which is really not nice. Quite frankly, if you're going to rely on the transcript you've had done, give it to everybody in advance, defense and prosecution, okay? Since you've adjourned the hearing for a week so the defense could respond. She said, quote, I can tell you this, and she said, what concerns me, and now I'm going to paraphrase, about if there's violations, what could be the exact ramifications on the client? And that's what she is concerned with. And that's a paraphrase there. And then she said, what Mr. Brennan supposedly, she was led to believe, had the same information you have. All right. So the defense did receive the transcript on 221. All right. Thank you, Dizzy. I thought she said that she's giving 5 minutes for everyone to review it, but I guess that's the defense packet that's now being turned over that she's giving to review. So that's a paraphrase, but what concerned her was that somehow she felt the defense misled her by not giving her information. Not that they affirmatively misrepresented this information, but when she had a concern or was expressing something, she didn't think the defense properly responded to it, to disabuse her of the information about who had what and when. And that whatever she does, she's been thinking about a lot, has ramifications, and she has to consider those ramifications. And then she said, and that led her to her number 3. And she said, the reason then why I adjourned this is I had to reflect. I had to reflect on the ramifications. So that's what's been going on here. That's basically the sum and substance of what the judge had. Now, we know that Mr. Jackson was at the sidebar, a sidebar we have not seen because, as you know, from the ASAP Rocky case, the sidebars, while they're in trial, are not transcribed. They're usually let go after trial. After trial, they are usually removed, although in some cases, I had one case and I was still gagged in Spector and there were no transcripts of sidebars for a long time. Maybe never in terms of the removal of the transcripts. But that's the situation. So we don't exactly have that whole transcript, although we should be able to get it now because it should be a public document since the judge has released it. So then, since Mr. Yannetti, as we know, had made representations before the ARCA testimony, afterwards, Mr. Jackson made representations not abusing her. So now, unless he's going to speak, and by the way, Ms. Shorty, thank you. Linda, you look tanking today. Thank you very much. Now we're back. Let's go into the court and let's listen.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
Yeah, good, okay. May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all, of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you addressing this in chronological order as well, right? Yes. So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your number
I will tell you exact
8
pages that I'm going to refer to. And Your Honor, get to this is tab 8
right.
of the notebook.
Mm-hmm.
And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend
You
my
can,
brief or keep going?
no, you can keep
Okay.
going, and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known, and that is the federal investigation and the products of that federal investigation produced the ARCA report, and that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is, the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or the defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background, that is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, The rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the hope.
Was the federal protective order that was referenced by Mr. Yannetti that said it was, and it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, no, I wanted to say it. I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question—
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes, and I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there, it might be at this point, wait a minute, you haven't had time to interview, et cetera, but what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. he goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's, Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right, I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask, and as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I'm well aware of that.
Okay, so he prepares it, he sends it along to Mr. Jackson, and it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom, is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations, that's why I don't want to go into it too much here, but there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue, because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question, when did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question, and that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement, to the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And, Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said, I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding, yes. And you were equally available to both sides in terms of them reaching out, correct? Yes, and I called you ultimately after receiving your report and asked if you join us and testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf, and I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676. Line 25, did you perform an accident reconstruction, specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe? Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, but the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's important, very important question. But it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just going
that.
to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
You are muted.
All right. We have a lot to unpack here. I will say, let me just give you my initial impressions. Mr. Alessi. Wow. Okay. I mean, that's all I can put. I mean, he has this down. The judge wanted to know how long he'd been working on this notebook. He said about a day and a half. It was finished this morning. He clearly is the one that has to argue it because the other two attorneys, Alan Jackson and David Yannetti, are more involved into what happened. So he's recounting what happened through documents. So tell your friends, come on and come all right now, because we are going to unpack what we have here. And I have a lot that I had to take down in Justice Serve TV. He starts with, I understand the moment. By the way, I saw there was a gifted membership up there. I want to thank you. We'll have to find it again because I can't. There we go. It was Shy Gal. Okay. Gifted one Justice TV membership. Thank you so very much. I appreciate it. But I was so busy trying to take down and highlight, as I would be if I were on the other side of the table, what was important. But he starts out by, I understand the moment, and I have a chronological order from February 18th, and I want to go through the chronological order. And he's very clear. He's very articulate. He uses words brilliantly. There will be no obfuscation. There will be no attempt. He's going to try to be efficacious, right, in what he does. He's going to elucidate. There's going to be elucidation, no obfuscation, but elucidation of what went on. And we will try to be efficacious with the court's time. You can see this is going to take us a while longer. And then, of course, Mr. Brennan gets a chance to respond. So this may take pretty much all day here. Chronological order, he starts with the transcript, right? And he wants to make notice that there's that transcript that Yannetti had that the court then said, look, you are calling witnesses you don't know. This could be a Rule 14. And the defense is saying we can't because the FBI, the Justice Department, the U.S. Attorney's Office won't tell us. We're not allowed to put down what's in the report to the other side because they were conducting a federal investigation, which, by the way, sources are reporting to other people. So this is hearsay that investigation is now over, but we will see. All right, but it was on Karen Reed, right? It was on Karen Reed. So he then goes through and he says, there's going to be 9 pages that are going to be very important later on when I get to another article. But what's really important to me, Your Honor, and what he made as an effect is that before the voir dire of Dr. Wolf and the other 2 people from ARCA who came in, but before the voir dire that the court set up as a remedy so there wouldn't be this discovery violation, they call it Rule 14 in Massachusetts, all right? That there was really only, you're talking about 2 communications from the defense and team, and that was from Alan Jackson. It even wasn't from Mr. Yannetti. It was always Alan Jackson to Dr. Wolf. And the first one was on 3/20/24, and it's an email, Alan Jackson to Wolf, engagement. And then if you should be allowed to testify or if you should be retained. There were words that had something like if to it, if. Okay, so there was that. And then there was after that, the proceeds of 3,000 pages, by the way, 3,000 pages, not after that, just before that, of production of documents from the feds to everybody, but to Alan Jackson, defense reviewed on 3/24. And in that was the ARCA report, so that they hadn't seen at all. And the ARCA reports were completely exculpatory to Karen Reed. ARCA was hired by the FBI to see whether an SUV could have hit John O'Keefe and caused his injuries and killed him. And they concluded completely that did not exist, that there was no factual, no scientific, no findings that would support the prosecution's theory of John O'Keefe's death, attributing it to Karen Reed. And, so he made a point that, we saw that, but that anybody, including the prosecution, could have called ARCA, right? Anybody. The prosecutor could have picked up the telephone and said, "Hi, Dr. Wolf, I am from the prosecution team. This prosecution, Karen Reed. I would like to talk to you about your report." Then let me just throw it in aside. If this were John Lewin from ASAP Rocky, in this case, on behalf of the state, you know that he would have picked up the phone. Matter of fact, he probably would have gone down there and taken a plane to meet him and almost cross-examine him while he's interviewing him for the first time. So the independent witnesses from the FBI were available to anyone. I surmise that the prosecution didn't want to pick up the phone, didn't want to call the ARCA experts. Why? Because they weren't on their side, right? They didn't want to have that conversation. They didn't want to then engage with them and listen to why they had found that the SUV had not hit John O'Keefe. So remember, we're in trial in April. And Yannetti, Mr. Alessi was asked to look at the specific trial date because it began because no one could remember, and points out that when Mr. Yannetti opened, he never mentioned the ARCA investigation. The judge had not, by the way, gotten that transcript. He'd gotten the transcript of Alan Jackson's closing, but he'd never gotten the transcript of the prosecution opening, which becomes very important because at that point, the defense did not know whether or not they could be able to use, or they didn't even know the existence of ARCA, and whether they could be able to use it. They're just getting this stuff from the federal government, which, if you ever dealt with the feds, let me tell you, things are secret. They don't like to share information. Maybe that'll change right now. I don't know. But sharing is not one of their things, especially when there's an active investigation. You can understand that, right? Okay, so. And what Alessi said, what I want to make clear before I go on is that no matter what we discuss here today, the findings of ARCA were set in cement. And on 2/24, both the Commonwealth and defense who had access to them, they were set in cement. From the time that the first time that the Commonwealth and the defense saw the report until the time Wolf got on the stand and testified as to what the conclusions were, till now. They were set in the cement. Nothing changed. There was no financial benefit to pay for anything and the FBI had said nothing can change because they're part of a federal investigation. So not a word can change, not a finding can change, not a finding can be added to, okay, in terms of what they do, okay? So any party, again, he said this again and again, has access to that. But then we're talking about the CV. And then what happened was there was an email, again, that paused. So there's two communications from Alan Jackson with Wolf, with ARCA, basically because he works for them through the FBI. They were hired by the FBI for the federal investigation. And then there was a pause because he didn't know whether or not anything could be negotiated on a retainer. And it appeared that the U.S. Attorney's Office said no right now, pause. The U.S. Attorney's Office set the rules. They're calling them the rules of the road. So there you go. So the Commonwealth never called anybody. The rules of the road were set. The report was set in stone. And this was important background to whether or not the judge had been lied to, or there had been misrepresentations made, or there had been a violation of ethical issues or a violation of Rule 14. But what Alessi said, this is very important background to understand, and he's absolutely right. And then and also notes that Mr. Yannetti, when he's making these representations of the court, he was not included on the two emails that Alan Jackson had with Wolf, which were really, excuse me, but in the legal term, kind of bullshit emails, right? Here's a retainer because now you're going to testify. We want to get some kind of attorney-client relationship, maybe. If you testify, it was never signed because why? Again, because the U.S. Attorney's Office said rules of the road. Pause. You can't do anything that's going on right now. But what happened? What's the second email? It's a CV. It's a CV. You could probably get it online, but he sent it to him. It's this qual. They call it the qualif that was attached, or the qual. We tend to call it a CV in our office, but they call it their qualifications, curriculum vitae, CV, and all. So when you testify, somebody can look at it and say, okay, so doctor, you graduated from what school? And could you give us a little bit of the benefit of your qualifications here? And that's it. That was basically it. And the judge asked at that point, was there a federal protection order in effect? And Alessi answered it by, I don't know, I can't tell you conclusively whether the order was in effect, but I can tell you conclusively that what the U.S. Attorney's Office said was in effect, that the report has to exist as it was thereat, that again, nothing would change. And again, it's brought home again by Alessi that nothing changed. Okay, so we have the U.S. attorney who issues the pause. There's no indication that anything's going to change. And then Dr. Wolf does send some emails saying, here's my draft questions. Now, here's what happens. Let me tell you what happens in the real world, okay? Attorneys make up their own questions for experts. Experts always think they know better, right? Well, here's my questions. And what the judge is trying to infer there is perhaps you knew what the report said. Well, everybody at this point knew what the report kind of said, right? Because it was going to be set in stone, and there's 3,000 pages that are coming, and the report's there, blah, 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 blah. But experts always think they know best. Attorneys know best for what they're going to ask. And what Alessi says, if you compare the questions that Dr. Wolf said to the questions that Alan Jackson asked, they're totally different. They're totally different. Why? Because we as attorneys know what we want to get before the court. We know how to frame our questions. We know what's going to resonate with the jury, and we know what's important in the case, whereas the expert thinks everything that they do in a report is important in the case. This is just a little back information on it. But I'm sure that an expert does get nervous if they can't get prepped, because you do try to prep your witnesses before they go on the stand. But here, they couldn't, because there was this pause that you really couldn't speak to them. So before they got on the stand, they didn't know the specifics of what was going to be said because they couldn't prep their witnesses. So what he then goes on and says, we couldn't get the engagement letter out. We couldn't pause. There was no agreement because there was this pause. And then he wants to go to the June 10th transcript where it references the voir dire. And that's where the judge just said the sidebar. So you've never spoken, to them. And Alan Jackson says no. to them. And the judge said, I find it hard to believe that you have never spoken to an expert that you're going to put on the stand. But Yannetti points out that he hadn't spoken to them, and the only communications were the 2 email. That was the one about the contacting them, well, here's a retainer if we could negotiate an agreement, which was never signed and never agreed to. And the second was the email regarding the pause. Okay. So there we have it. That's the only AJ really letters to emails. I shouldn't say letters, emails to. So he didn't speak to him about what was going to be testified to, and he didn't prep him. And that's apparently why the Dr. Wolf was so concerned that he's going to go all the way to Massachusetts to testify now in a case, and he's never spoken to him except for the purposes of. And we talked about this on our pre-trial here. Remember the pre-hearing here with Michel Bryant, with the purposes of coordination, okay? And coordination can mean a lot of things. It can mean, well, there will be pay for expenses. When do you come in? Where's going to be your hotel? Are we going to pay for your food? Blah, blah, blah. And he said, look, you, the Commonwealth, could have done the same thing. You could have interviewed them, but the Commonwealth didn't do it. So he saw that the word expenses, coordination, coordination has, and he says, I have the Merriam dictionary, Webster dictionary of coordination. Hey, somebody in our chat, look it up, see what they talk about is coordination, right? And coordination doesn't mean you lied to with regard to when you're going to testify and all, but they didn't have conversations about what he was going to say on the stand because of the clause. The court. He then goes to tab 3. Mind you, it was stopped just now at tab 8. Thank you again for the one gifted membership, Shy Gal. All right. Tab 3 and the voir dire. And he says, we bring them in the middle of the trial for this voir dire. And he says, unless he says, look, you're the prosecution, not because Brennan wasn't on it then, could have asked any of the questions. But was there a compensation for the report? No. Was there a compensation for the findings? No. Was there an inducement for the findings? No. Was there any promises of rewards for the findings? No. Why? Because they were set in stone, and the rules of the road were that report could not change because they were hired by the FBI, Department of Justice, for the U.S. Attorney's Office into this investigation into Karen Reed or the Canton Police Department or whatever the investigation is for this particular case. And they said they didn't ask a specific question of any of the doctors on the stand about whether they could be interviewed. And he says, you know that the prosecution knows how to do a proper voir dire. We listened to Dr. Russell for how many hours and how many days. Remember, she's the dog bite expert for the defense about a voir dire. And they didn't do any of that. They didn't basically ask one question. And he says, probably because they didn't like what they were hearing. So his point there is that the prosecution, even if Your Honor finds that there was a certain violation of some sort, there's no prejudice to the prosecution because when they came in on voir dire, before they got on the stand in front of the trial, the jury, because that's what the court ordered, that they had to be voir dired, the state, or the Commonwealth, as it's called in Massachusetts, could have asked any of the questions. But one of the questions that was asked on direct by Alan Jackson, that the state is now objecting to and says was hidden, was human factors. What are human factors? Do you have a lot of cases with that deal with high visibility at night and hitting of pedestrians and night human factors, et cetera, et cetera? And again, those were asked but not followed up by the Commonwealth. So when you say that there's questions regarding that or complain that, hey, you asked about human factors, you should have known, it could have been easily that the Commonwealth asked the same questions that Alan Jackson did, and they did not. Then he moves on to tab number 4, June 22nd, 2024, an email from Dr. Wolf to AJ, Alan Jackson. And he makes a point that Mr. Yannetti was not on these emails. Why? Because in the way this case is being tried by the defense, with them being all over the United States, they don't get together in those conference rooms and meet. And this was certain duties that were assigned to different lawyers and all. And so that the ARCA people were AJ's witnesses, Alan Jackson's witnesses, as he's called, and he was the one dealing with him, not Mr. Yannetti. And this is in the middle of the trial, right? In the middle of the trial. And then it's verbatim about the, after he says, well, he says, I like the questions that you asked me. You asked great questions, okay? He said, I'm working on a draft of my questions. Again, we talked about that. And then the emails from Wolf to Alan Jackson with regard to his qualifications and his questions. We talked about this email because Alessi had touched upon it earlier also. And that's the extent of it. But it's not that it's not that he's given Alan Jackson the specifics of the report at that point. He's telling them specifically what's in the report. He's just giving his idea of what questions to ask, which apparently, if you compare the two, says Alessi, are not the same. And then he goes to question 19. That's the night visibility question. And where Wolf says, well, if you don't want me to say anything about that, I won't. Okay. But there's already been this voir dire, right? Where it has been mentioned. So it's not Alan Jackson saying don't say anything, because Alan Jackson is the one who brought it up in the voir dire. Okay. So there's no hiding anything from the prosecution, makes the point Alessi makes. And then he goes to Wolf Direct, and he said that basically he asked the court to compare the direct of Wolf to the report of Dr. Wolf, and they are the same. The findings of the report and the findings that he testified in the court are the exact same. They work off the same document, basically. In other words, the testimony could almost be the report and all. And so he says, so therefore, what is the prejudice to the Commonwealth, right? What's the prejudice to the Commonwealth if indeed there's two emails, if indeed Alan Jackson is not asking the questions that Wolf wanted, if indeed there's only a qualification set, your CV, which somebody can look up, and you could probably look up and get Dr. Wolf's qualifications online right now. What's the prejudice to that? And indeed, the Commonwealth could have picked up that phone. Again, Wolf, Alessi keeps going back to these same points about everybody having equal access here. Now, I'm just going to pause here for a second, because I did remember hearing when this was set last week, Brennan making the argument, the reason the Commonwealth didn't pick up and call Dr. Wolf, because they didn't want to interfere with the defense's ability, attorney-client ability to call Dr. Wolf as their witness. Huh? What? Huh? People call expert witnesses from the other side all the time. Sometimes they call them cold clock. You hire an expert witness, you've given the expert witness's name over, and what does the expert witness get? The expert witness gets a cold clock from the DA or the other side if it's a civil case. And then if the expert says, hold on, I just want to let the other side know, you want to let the people who hired me know that you want to talk so they could also be on the phone, then they say, you're not cooperating, you're hiding things. Okay, so, this is all a little bit of a game here and all, because there's no reason for them not to pick it up. They weren't interfering with any attorney-client privilege, because the privilege really went to, what did it go to? It went to the U.S. Attorney's Office, because there was no engagement letter signed by the defense here. But I'm giving you a little inside baseball of how lawyers think, but you already know how us lawyers think. Okay, that's why you're here. All right, so then he says, again, he makes the point that the retainer agreement was never assigned. So therefore, what could be the reason the prosecution didn't call? The reason the prosecution didn't call, as he says, is because they didn't like the answers. They didn't like what was in the report. So, he says to the judge that of course, there was a special prosecutor, and the judge knows, blah, blah, blah. And he also then starts to speculate again about why Dr. Wolf may have sent questions, and the judge tells him not to speculate. And Alessi says, yes, Your Honor, I won't. And she repeats it, but he says, but I am going to speculate one other time. And that's because Mr. Brennan last week made a lot of speculation, Your Honor. So I'm going to warn you right now. He didn't say the word warn, but I'm going to tell you right now that I am going to respond to the speculations that Mr. Brennan made when I get to that point, which they're about to get to that point now. And that's why we took a break. But then he wants to go back to the transcript, page 3676 to 3677. And he again makes the point. The findings of Dr. Wolf never changed. and all. Net findings never change. So we get to that. And then he wants to move on to tab 7. And this is an important tab. This is the invoice. He says, so what about this invoice? Because then the question is, was there a prearranged agreement that this invoice would be paid so that when the defense made the representation that that ARCA had no skin in the game, they really did have skin in the game because they knew that they were getting paid? Well, number one, the invoice didn't get sent by ARCA well after the trial ended on July 12th, 2024. July 12th, 2024. And by watching the interactions there at counsel table, it's clear to me that Karen Reed and whatever a financial group she has put together really controls what invoices are paid, because they had to go look it up, because the judge says if it was paid and when was it paid. And Alessi goes over to try to get an answer for the court. But he wants to point out first that when they got the invoice, there was a big surprise. They had to call the U.S. attorney and say, "Can we pay this? Can we pay this? We didn't have any agreement to pay this. Should we pay this? And we don't know what the line items are, if they're for travel, for transportation, for food, or whatever." And the U.S. attorney says, "Yes, you can pay it because our contract with them has now ended, basically, so you can pay it." Now, the judge is getting back on the bench, but the invoice was paid apparently on the 25th. So why don't we go back and hear? I didn't even finish everything, unless I still have a page and a half, but let's go back to the court and listen.
So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We've talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson, and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now, with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be in some points a line by line, because the words matter. Line 5, and this is again is Attorney Brennan. Mm-hmm. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55, Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you, my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, "Hi, Alan. Subsequent to our conversation on Wednesday," this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates, so it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, "Now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field." That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, "Alan, I spent some time this morning putting together a brief outline of my qualifications," blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. Mine. That's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay, Your Honor.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a time frame.
That's my best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
All right. Before I just go into where we broke before lunch, I want to continue. Remember, I told you I still had a page and a half of what Mr. Alessi said before they took that break. And I love it. I hear goodbye from in my ear from the courtroom because I guess they're cutting off the stream there for a second. All right, so what happened after this whole invoice? Right, what they received the defense. We talked about it. The defense called the U.S. attorney, Mr. Adam Deitch, and said, "Can we pay it?" It came out of the blue, and he said no one's more surprised than one person. He said, I can't give attorney-client conferences. That one person who gets an invoice for testimony for something that the trial that ended, previously, and wasn't expecting it. And it's apparently a lined invoice. We have not seen it, so it's got a line by line. Apparently, must have travel and everything. And he said, yes, you can pay it. So they paid it, or it looks like. Because I had to go to the computer where Karen Reed looked at her computer and looked at, I guess, to see what checks had been given out, and they paid it on July 25th. But what was important there, he says, Your Honor, I've made the call, right? Your Honor, you can call Mr. Adam Deitch of the U.S. Attorney's Office, and you can ask him. I made the call to confirm because I'm investigating this before I present it to you. You can, and remember, they were only given like about a week to do all this. You may call the U.S. attorney, and Your Honor, you talk to the U.S. attorney and you ask him if my rendition that Alan Jackson called in disbelief that they have an invoice because they hadn't signed the retainer and everything was paused and wanted to know now, do they pay it? And the U.S. Attorney's Office said, yes, you can pay it. So that's kind of like the high point of where we left off before they took the break. So I thought at that point the story kept getting worse obviously the Commonwealth never made any contact at all except to send the TUI letter, which is a letter to the government to try to get another government agency to try to get whatever they have with regard to the investigation, in regard to everything that's going on in this case. So then after the break, Mr. Alessi comes back, and the judge, I guess, is a little worried about time. At one point, she tells him, don't tell me what you're going to do, just do it. Like the attorneys in the courtroom who will get up and say, Your Honor, I think I'm going to object, or Your Honor, I'm going to object. And a court will usually say, in a federal court, stop saying what you're going to do and just say the word objection, because telling me what you're going to do is really wasting my time. So she didn't want to hear that. So she kind of shut him down a little bit there. But he goes to page 53, line 19. And quite frankly, he now starts talking about what Michel Bryant and I talked about with you before we started today, a number of things they've hit upon. But this is how Mr. Alessi phrases it. He says, I'm going to read you the words of Special Prosecutor Brennan, because, quote, words are important. Words are important. And this is from clearly Mr. Alessi, who's kind of a wordsmith himself, and all. He said, and he quotes that the prosecutor said, "My purpose is not to deprive the defense of an expert." And I mentioned that to you earlier because that stuck out last week in my mind, that there was some indication that if the Commonwealth talked to the experts, and we just talked about that before we broke, that somehow that would mean that the defense could not use that expert. And that's simply not true. It's simply not the case. So Alessi honed in on exactly what Michael Bryant and I honed in on, that we spoke to you about earlier on. And he said the reason why that matters is because, again, you said you didn't have any contact with the U.S. Attorney's Office, but then you say that you didn't get the information from the defense, that you got it from the U.S. Attorney's Office. And he intimates that that was actually an untruth. Should I say the word lie? Because that's what he intimates. And we also talked about that because last week when we were all looking, everyone went, "Oh, it's Tizzy. Oh, the defense didn't provide the information. They had to get it from the feds." And then he goes back and about a minute later or so, he corrects it. He said, "Oh, I should have said the word defense, not." But in the meantime, the word got spread around X, Twitter, and social media that the defense had done something wrong. Yes, we all can make mistakes of what we said, but this was kind of a big one. So Alessi calls Brennan out on that and said the Commonwealth was basically making these misrepresentations, and that the defendant turned over the information. And at the time the Commonwealth made these misrepresentations, basically, is what Alessi is saying. And I'm classifying that as misrepresentations to the court. They had had discovery for 5 days previously. That's for the discovery. And then last week when the Commonwealth said that they didn't want to deprive the defense of the expert, that's why they didn't call the U.S. Attorney's Office or ARCA. They had the information and they could have called, and no one was preventing them from doing it. And makes a big point again that the defense provided this information. So any indication that the Commonwealth was trying to say otherwise was simply wrong. And when the Commonwealth said to Your Honor, "There's much more to the story," well, he says, "No, there's not much more to the story. Call the U.S. Attorney's Office and find out." There's nothing more to the story because they didn't say anything. They didn't call us about the bill and all. They didn't call us about whether people could be paid. They didn't call us about anything. You talk to them, Your Honor. Again, you talk to them. And so he said, you get a bill, you pay it. The U.S. Attorney's Office can be asked about all this. And then again, he hones in on the fact, again, in a different way, that the defense provided this information to the Commonwealth, not the U.S. Attorney's Office, the information they're complaining about that they did not receive. Now, at that point, he wants the court to turn to page 58, line 2, that this was provided by the defense in reciprocal discovery. And since he appeared to be starting a new area, even though it was not a new tab, my understanding is there's 8 tabs that he has to go through, that indeed that's when there's going to be a break here. And both the court reporter and everyone needs a break, needs lunch and all. So that's what's happening right now. We're still waiting to hear from Michel Bryant. He has been outside that courthouse listening, but I'm sure right now, since they're all heading for lunch, he's trying to get interviews with his Justice Serve TV microphone. I will note you that when we were buying these, Michel Bryant said for me to buy this one. It doesn't even fit our little thing. And he's got this big Justice Serve TV microphone out there because everyone kind of out there now knows who we are. We've been there covering this case, and we will be covering this case through trial, including next week when there is an interview, when there is not an interview, when there is a lot of motions now, it appears to be. But the most important one is the full-throated motion for dismissal of the indictment that is going to be heard next week, apparently with several other motions that's on the calendar. That calendar that Judge Beverly Cannone put together well, it's going by the wayside, and with this intent to get this case in on April 1st and all. So it really is happening. So I want to see whether or not we have any more questions. Again, yes, thank you, Miss Jordy. Thank you. That's very, very sweet of you. And I'm hoping we're giving you good information. So what I think we should do, since Michel Bryant is right now probably getting interviews until they come back for lunch, I think what I'll do is, let me text him. Let me see if he has everything set up and all. And then we can go from there. Now, hold on one second. Let me text him. And in fact, you'll hear me. Are you set up to get back on the air since there's lunch break, or would you rather do that at 2? I assume you're out there getting interviews. So let me text him. Let me send him that text. Let me give him a minute or two to answer, because I don't know if you've seen the scene outside the courthouse. Apparently, it's crazy is not the right word, but it's flowing. It's loud. There's a lot of people. There's a lot of supporters. There's not areas set away for, or areas set aside for media interviews, like some courthouse will cordon things off, because it's very, very small. And it's in the middle of a neighborhood. And as you can see, Michel Bryant's parked 2 blocks away, and he was in the middle of a hood. He said that he had all of his equipment out there this morning, his seats, his lights, and all. Everyone's going, "Hi, how you doing?" They're kind of used to it right now. And so I'd love to see what people in the neighborhood are thinking about this. And what I suggest, Missy, if he doesn't answer me with, I'm hearing him. I'm hearing him get on actually right now. So he is answering me. Wow, I'm impressed that he is. Michel Bryant, not even the text back, just got on for our viewers. Where are you now? Let me ask you, did you hear everything that happened? We just had a long discussion about it all with our viewers. And secondly, where are you now? Thirdly, what happened? Did people exit the courthouse for lunch? And fourth, do you have any interviews you're going to show us later?
I do not, and let me pick up where you left off there. Okay. I'm sneaking up on the courthouse. As you can see, it's now behind me here, but I'm just really just a few blocks away.
It moved, and you moved.
It moves. I'm going to get even closer. I didn't want to waste all our battery power on this lunch thing. Not a waste, but I have my car right here, so I can save the battery for post. As to where people end up, right across the street is the clerk's office, where they have the great bathroom. They also have kind of a cafeteria, lunch area. And that's where all the supporters, Karen Reed supporters, go to watch. So they just go down there and they watch. I'm saying, hey, check out Justice Serve TV. It's the same feed. So they're watching there and getting ready to make their appearance at the end of this hearing, assuming it ends sometime today. So that's the deal. I've been chatting with some folks, and I did upload some street video, and I have talked to some supporters that I'll get to later. We'll just upload those for our members, just to give them a sense of, why these people dedicate the time and effort that they do to be out here. It's impressive. So anyway, I've got my voluminous notes here, and I was listening to you earlier, and I think we were in sync on a lot of these key points, and I'm not going to regurgitate them, but let me go back to one point I thought was pretty important and maybe glossed over. We know that the emails that took place in March of 2024. March 20th, the first one. March 22nd was the second. The first on March 20th was, again, that was Alan Jackson to Dr. Wolf. In that email, there's a reference to a phone conversation prior to that email. I can't remember if it said that morning or the day before. I think it might have been the morning. What happened in that phone conversation? We don't know the context or the content of that phone conversation. So to me, that's a big gap. I kind of like to know that. I don't know that you can go forward, expounding your virtue and how everything was above board when we're not sure what happened in that phone conversation. And I'm pretty sure we will never learn what happened in that phone conversation. It certainly wasn't transcribed, and unlikely it was recorded. So I think it is key that in that next email of March 22nd, at that point, the feds had said, hey, you guys just stand down. Whatever it is you're doing with regard to these experts, stand down. And in fact, they did. And that is key. There's no doubt about it. Had there been further efforts to engage the experts from the ACA, That would be a problem for the defense. But clearly, they did stand down, and there was no further communication at that point going forward, other than they got the CV and so what. Nothing that any expert wouldn't provide to a prospective hire, right? And there was never any engagement actually completed. So that's key to the case. Obviously, if you don't have an agreement, then there is no retention. Then it's all about what communications you did have leading up to any attempt to engage these experts. And from what we know, there was the 20th email, there was 22nd email, but there's still a big hole to me in terms of the phone conversation that took place before that March 20th email. Do you have any thoughts about that? Any concerns about that, LKB?
No, I thought that, it kind of got glossed over, but the fact that there was a stand down, that everything was on pause and you can't, and they didn't have any conversations about the substance, I don't think. I think that's basically the representation here, that there was nothing about the substance. I don't see how she gets into that. I mean, she could ask him, does she ask him to get on the stand? Is that what she's going to do? Does she ask Alan Jackson to get on the stand? I don't know.
I don't know. That's a very good question. It'll be interesting to see what happens when Brennan gets up to refute whatever issues he wants to refute. Maybe that will be one of them. Maybe it will say, well, hey, this is all great, but what the hell happened in that phone conversation?
Right. Or why are we taking the representation that none of this was discussed with Yannetti, because clearly they're preserving Yannetti, to stay on the case because they're saying he wasn't copied and all this. So that's a clear preservation, right?
No doubt about it. And so there's the reference to no substantive conversations took place. Of course, those are key words. We were talking about it before the hearing began. What was just organizational, meaning scheduling perhaps, but what substantive conversations took place? And the representation by Alessi is there were none. So that obviously is going to be key to the court's decision in this case, and to the Brennan, I want to call it the response. It's a weird context that we're having this hearing, because very seldom do you get an expert drop out of the blue, and then you're discussing who actually retained the expert and who's using the expert in a given trial. So that's going to be very interesting to hear Brennan's response to all of these things. I do like how at times Alessi is definitely an acquired taste. I know you love the guy. I think he's amazing.
I thought he was great.
Obviously very, very intelligent. But
I don't say he has jury appeal. I'm not sure he has jury appeal, but I think...
No, I'm just analyzing him as someone in the audience, listening to the argument. He is detailed. He is a little ponderous at times. And I think he gets rattled just a touch when the judge will say, "All right, Mr. Alessi, don't tell me what you're going to tell me. Just tell me." I think, okay, Judge, I will tell you what I'm going to.
Got rattled there.
He does. When he gets pushed off his game, he does take a beat to catch back up and get poised yet again.
Brooklyn says he's book smart, and he absolutely is book smart.
There's no doubt about that. Oh, he's a smart dude. Oh,
I bet he plays chess because he's so detailed in how he organizes, right?
I bet he
plays
chess. Three-dimensional chess.
Right. You know what that is?
I still don't understand how anybody plays that.
Right, but they play it in their head. Well, my client, who is a women's grandmaster, Jennifer Shahadi, she could have, I think, 6 games in her head, and she can play them all in her head against different people.
Yeah,
so it's an amazing thing.
Yeah, right. It's gifted with some sort
maybe
of
more. Maybe I'm undercutting her. Maybe she plays more, but yeah.
So there was also a mention of the voir dire. Remember, after the 6/10/24 hearing, the court said, okay, well, we got to get these guys in here and open them up to voir dire. And Alessi is saying, prosecution, what are you bitching about? You had every opportunity to ask them every question you possibly could have asked them, including retention questions, right? And conversations you had or did not have with the defense at some point prior to this voir dire and before you're going to testify. And according to Alessi, and I haven't read the transcript of that particular hearing to double check him, to fact check him, but I have to take him at his word because it'd be easy to catch him if he misrepresented that. They didn't. Right. The prosecution did not ask some of those questions that would have answered any concerns that they had that there was something inappropriate happening between the defense and these experts. I was looking at my
Michael,
notes here.
remember when we were worried that this hearing was going to be over? You drive back
I
to
know.
Connecticut, and then
Never
you make
mind.
it back by the time for the judge's opinion. I don't think we're going to have a judge's opinion today. We may not even be finished the hearing.
Yeah, and I'm more concerned about, and this is how dumb I am. I left my laptop charger, and so
Oh dear.
I'm okay for now. I'm okay for now. Trying to make sure we save enough juice for the posts, whenever that may be. And I may find a way to charge it up. I'll work on that. But I've got battery power for the Starlink, which I think will be fine. Which will be fine as well. But hey, I know I could do it on my phone. I'm just figuring this thing out on the fly. I think I could do it on my phone as well. Anyway, you talked about the transcript at 58.2. Remember that, where there was talking about information provided to the defense, and there was a question: was it information provided by the defense or was it by the feds?
Right.
And so it's not normal. And I know you've talked about the court reporter in this case being somebody you worked with, and she's got that diminishing skill, not hers diminishing. You don't see it often in the sense that it's diminishing. I can't remember what they call that, a voice recorder. I can't remember their specific title.
I don't remember,
but you don't hear an attorney questioning that very often. They kind of live or die with that report.
Except that he questioned it only because he said that I'm going to give Mr. Brennan the benefit of the doubt, right? So now he's pitted the court reporter against Hank Brennan.
He's basically saying she got it wrong.
If you give Mr. Brennan the benefit of the doubt,
of course. But what he's saying is, especially on the second statement, defense provided the outline. Defense provided, I guess it says an outline. Defense provided an outline, and it was not the defense that provided an outline. I mean, so I don't know how that can be misconstrued. I can see how isn't right. That could be rushed along and misheard, but I don't know how they get past that one. The other reference was this isn't information provided by the defense, and I think it was. So that was an isn't confusion. Again, this is Alessi suggesting the court reporter, got it wrong. And let's face it, this is a human doing a very difficult job. Yeah, of course they occasionally can get things wrong. There's no doubt about that. A little critical here if that is the case, though. I think they get so much benefit of the doubt, though. Speaking of giving benefit of the doubt, most people would defer to the court reporter. They're so skilled. They're so good at what they do, and you're so reliant on them being good at what they do. I think most questionable points would go for the court reporter.
But it is interesting, though, because really the transmittal, though, of the documents in the transmittal to the prosecution is going to count. So if they gave them 5 days before, and the transcript says wasn't or is or isn't, but the fact is that the transmittal shows they had them 5 days before, the transmittal seems to me would count, right?
You would think, right? Let's talk about another big issue, and that's the invoice, right?
Right, that's a big issue, right?
Yeah, so the invoice is sent out on the 12th of July, and it comes as a surprise, apparently, to everybody on the defense team. And Alessi's talking about how there's this division of labor, and not everybody is truly understanding what's happening. One hand is doing one thing, one hand is doing the other. And as for the payment of the bills, that could be even a third party, right? So the question really was, why was there a bill sent? Was that in the request of the defense? Like, hey guys, we're done, great work, send us the bill, right?
Right.
Or was that just something the experts decided?
Right.
My take on it is they just decided to send a bill. And there is.
That's my take, too. Right.
That's what I'll tell you about something takes place in the legal profession in terms of billing. I'm not telling you this, but let me tell you, there's something called result-oriented billing. Are you familiar with this concept?
Yeah, they wait and see. They wait and see. They don't think they're going to get paid, but then.
If I will just suggest that winning this case was a $24,000 invoice. If they had lost the case, it might have been a $10,000 invoice. You understand what I'm saying there? And so this invoice was generated primarily, in my opinion, because they won, and not at least in some measure, to the experts who suggest that, oh, by the way, that Karen Reed SUV never hit John O'Keefe. Not sure that's what happened in this case.
They work for this organization. We don't even know who the billers are. The billers may say, hey, wait a second, you testified. Hey, we're sending an invoice, man. Yeah, we're not eating this bill of your costs and expenses.
Yeah, and so my little story gets beyond the nuts and bolts of this particular invoice, but it is a fact in the business that there is result-oriented billing. So this bill comes out on the 12th after the jury has failed to come to a ruling, a verdict, and so we've got a hung jury. They send out the bill. But I think not just this bill, but the second email, which was from the, the first email from the 20th, those were things initiated by the experts, not just, hey, we'll send an invoice and see what happens. You know, what the hell? We got nothing to lose. Let's send an invoice. It also relates back to the questions. Remember that Dr. Wolf said, hey, I'll put together some questions that might be helpful. That was my paraphrasing. Well, there's a big difference whether Dr. Wolf initiates that himself or whether he is asked by Alan Jackson to do that, right?
That would be the judge's question, right?
Yeah, and this would be, sorry, I'm dropping my notes all over the floor here. And by floor, I mean sidewalk. So in this case, it sounds to me like you have an expert who's in a weird position. Because let's face it, it's weird. How often do you have an expert that has not been hired by either side in a trial? And Dr. Wolf is a doctor. I'm sure he has testified plenty, but that's not his job exactly. So he's nervous about it. He's, you know, he is putting together this list maybe for himself as much as anything else.
Right, and so, and then experts who haven't testified get nervous.
And that's a huge issue because if, let's say, in that phone conversation, which we don't know the total guts of, included some reference to maybe you could put together some questions, or maybe you can let me know, what direction you think the questioning should go. If there was that kind of direction prior to that March 20th email, to which the doctor says, hey, I'll put together some questions, that's a big issue. That's a bigger deal. Unless it was totally Dr. Wolf saying to himself, I need to know, what's going on here. This is a weird situation. I don't want to be ambushed. I want to get on the witness stand. We just don't know. That I don't know if we'll ever know that, but I think it's a critical issue this court's going to have to deal with.
That's and how she gets there, if she thinks that is. But the other thing is, at this point now, what about the argument, no harm, no foul? This is a new trial. I mean, you got everything. Here's a new trial. Now you can question them, about that.
I think this is far more about the ethics and the representation than the substance for the trial, whether we're talking about the expert's testimony or whether we're talking about the merits of the case. I think this is purely attorney representation and whether or not everything done was appropriate under the professional rules of responsibility. That, I think, is the judge's concern. I don't think it has a thing to do with the merits or the expert's testimony. Well,
you know what, Michael? Let me just say something. You move to try to take, because really what he wants is Alan Jackson off the case, right? This is what this is about. Alan Jackson is a really good attorney. I tried Spector against him. He's a really terrific attorney. Sometimes maybe you shouldn't ask for what you're looking for, because maybe you're going to end up with someone like me, not in this case. I wouldn't take this case. Joe Tacopino, Jose Baez. Okay, maybe you don't want what you asked for, and you should just let sleeping dogs lie.
There's an argument for that. There's also an argument that as a zealous representative for your clients, if you see an opening, if you see something that might help your client, you got to go for it. And in this case, the client.
My point is it may not help him. Okay.
Oh, what do
you think you're going to get? What do you think you're going to get? You're going to get somebody lesser than Alan?
Well, then we're right back to the Sixth Amendment issue, and can the trial go forward on April 1st, which seems to be the court's primary objective, right? I think this may all become a whole lot of hullabaloo about nothing. The points will be made, warnings will be made, and nothing will change. We'll just go forward on the assigned date. That's my guess. Mainly, I say that because the stuff we've learned today, even so far, has watered down any suggestion that the defense was inappropriate. I think
big time. I think it's a big time watering down. But I think that the hullabaloo came from Brennan representing, we didn't get this from the defense. We had to go to the TUI. We had to go to the prosecutors and get it. That's where we got it from, when they had it from the defense. Now, why isn't that a misrepresentation? Why isn't that a misrepresentation?
Well, it was brought up by Alessi, and I'm assuming Brennan will address that, saying that this was not an attack on them. Maybe they got it from both sources. I don't know. We'll wait to see what he has to say about that. But on its face, it does look like you're throwing the defense under the bus when you may not have really needed to do that.
Yeah, and when you didn't do your due diligence, as we call it, right, and pick up the phone and call the U.S. attorney that was in charge of this. Now, apparently, this investigation may no longer be in existence, so that's going to be an interesting thing. What does the judge do about other ethics issues? You got Proctor, who's had his second day of his hearing to be removed, right? What do you do about that? Do you just ignore that? The state puts him on, and he's, whenever you put on a witness, lawyers like to say we don't vouch for our witnesses, but you're putting them on, right? Knowing all their foibles and their lies and all their baggage, as it's nice.
Yeah, of course, unless it's the Relly rule. But you can, if you're treating a witness as hostile, then you're effectively not vouching for that person, but you need them for whatever foundational information they may have or impeachment purposes. But yeah, so you're not anointing every person you put on the stand, but you got to make it clear to the jury.
Wow.
What's been the feedback out there? Because I haven't really been able to watch or see any of that stuff.
I haven't looked at. Our viewers are not liking Brennan. I mean, they're in love with Mr. Alessi. Let me see if I can go back. And they think that it's an unfair playing field. That when the prosecution does something very bad, that they don't get anything. Nothing gets them. I put this up here. I put Afton's comment up. Richard Glossop in Oklahoma. This has nothing to do with this case. Just got a new trial. He'd previously been convicted and sentenced to death penalty. I just want to crow a little bit that my husband gave one of the original reports to try to get this case overturned for the Glossop trial team. I don't know whether or not the new trial team will be using him or not, but this was years ago. He did write a report in the Glossop case. So I'll just crow a little bit about my husband, who did get the Innocence Project. As you know, you were there, award last May for all the work he's done pro bono for the Innocence Project and all these type of cases for the last 30-some years. So I just wanted to crow about that.
That's good. That's another amazing success story for the
thank you. Anyhow, so let's go through some of these comments right from the beginning. Oh my God, I couldn't read some of them. Some of them are really tell us what you think, right?
That's okay. We're all
Shy Gal 8, who also donated a membership today. In my opinion, I was livid over the dramatics by Brennan and Judge Beverly. Where was the outrage for Karen Reed? Okay, that's one of the things, right? Everybody's very happy to come in. Let me go back to some of these. Some of the comments, some of the comments are comments between our commenters, which I really can't read. But most of them, and if you support Brennan, this is a safe place. Tell us why you do. Tell us why you do, because everything I'm saying is that Alessi is hitting the ball of the park. Again, touche. Why is she all of a sudden so careful when the defense actions are called into question? She's pretty factualizes. I'm pretty sure there's an email from ARCA to the defense saying they don't need a retainer. I don't know if that happened. I don't think we saw that happening at all.
It's like it never got that far. When they got the shutdown email on March 22nd, it sounds like there was nothing, and then out of the blue, the invoice comes after the trial ends.
Yeah. Factualizes, I'm guessing the Commonwealth missed out on a lot of emails. Happy Annie said Alessi is going to make Brennan look like he has egg on his face. It's very possible that he did. And then the Judge Beverly is she's got to have some concerns now about going after Ellen Jackson, because I think that was her first grave concern, right? And when you put this in coverage as he did in terms of step by step, it's a whole different story that's being told. What do they say in Hamilton? I want to tell my story because the way I tell it is the truthful way of telling it. So Yeah.
So
So,
from the other Karen, thanks for covering. Oh, you just
oh,
got.
I'm
Just do that
sorry.
to
I'm
me?
sorry. I'm sorry. Could we get that back?
I think she
We get
said,
that back. Yeah.
or the other Karen said, is this a gray area? And I think it certainly is if we're talking about the degree of any misrepresentation. There's negligent misrepresentation. Oops, forgot, made a mistake, didn't talk to somebody, gave you the wrong info. There's intentional misrepresentation, which is a lie. And then even beyond that, fraud, where you use it intent that lie to get something out of it. So far, this is looking to me like negligent, if anything. But we haven't heard from the Brennan side yet. But I think I don't want to attribute to the Brennan side. I'm going to give them the benefit of the doubt, as Alessi has, to intentionally trying to sabotage the defense. I think they found something they thought was questionable. They brought it to the court's attention. And maybe they, for the first time, are hearing things they didn't know before. It's changing their mind.
Well, I don't know if Brennan's going to be changing his mind because, but the problem is that he did get into the case, right? So this was not his case on the first trial, right? But Alessi, somebody points out again, Chi-Gal, Alessi's on fire. He's buttering her up. He did have a way of saying when she did kind of like not yell at him, but suggest that he should move on with it. Oh, yes, yes, Your Honor. I'm gonna don't worry about it.
Yeah, he is to say he's deliberate is a nice way to put it, but he has a reason for every word that he uses. It's just that sometimes we don't need the preamble. Let's just jump right in, dude. Don't. Some people will tell you what they're going to tell you, then they'll tell you what they told you. And sometimes that's important. Sometimes with preliminary facts, you just don't need it. Just get in, man.
Well, that's what you do to a jury. You tell them what you're going to tell them. You tell them what you're telling them, and you tell them what you told them, so that they could. That's what you do. But I'm not sure you need to do it to the judge. Although he is. Look, they know that she wouldn't have had this hearing unless she was after somebody or wanted to do sanctions or ethics or something, which could follow anybody around, right?
Right.
If you get an ethical finding by the judge here, that could follow you into California, so that they know that this is an important moment. What was the words he used again? Let me go back to my notes here, Michael.
When his first few words, when he said, "I understand the moment."
I understand the moment. Okay.
Which is an interesting way. That's a very poetic way of saying, "Yeah, we get it. This could be a big deal. We get it."
Right. We get it. Right. And
Brooklyn says this is such a waste of time. Instead of getting ready for trial, the judge is dealing with this nonsense. I don't disagree entirely, except that you need to find out if it's nonsense. You can't just assume certain things because the holes in the story from last Tuesday were big enough to drive that giant truck that just went by right through it. You have to sew these things up. You can't go forward with these big questions hanging, like a matzo ball over this second trial. You can't do it.
Oh my goodness gracious! Ms. Shorty, yes, Texas, Brooklyn. There's a lot riding on this trial. Yes, that's the problem here. Got to keep things light and airy when possible. I'm not sure Mr. Alessi knows how to keep things light and airy. That was an explanation to what's going on. Law and Order thanks us for understanding what's happening. Love our legal input. And then thank you, Chi-Gal, again. This is our new Karen Reed trial. Yes, we're going to be on this case. And I think that we give you the insight, Michael and I, from being trial attorneys as to what's happening. And also the insight, I've tried a case in Massachusetts. I've tried a case against Alan Jackson. That kind of insight about the intensity that's brought to this type of trial. So generally, at least I haven't checked social media. Why don't I do that while you talk to our viewers about this? Let me check social.
Here's something I found. This was part of Alessi's argument. I found this interesting and convincing. He's talking about the questioning during trial number 1 of Dr. Wolf, and this is questioning by Alan Jackson. And he focused on a number of different questions. One of them was, you did not know any of the defense counsel. That is correct. So what Jackson is doing is laying out for this jury that, hey, we're not in bed with you as an expert, right? That's critical for this hearing, because that's kind of what the prosecution has been suggesting, that the defense is in bed with these experts, and they are not as independent as has been represented. Another question was, the defendant had nothing to do with your opinions or conclusions. Correct. You haven't been paid by the defense. That is correct. We know that didn't happen until about the 14th of July.
But
You
now,
don't work.
but now there is a payment. We haven't seen the bill to see what the line item is. The 24,000 could be for a lot
Yeah,
of.
well, I mean, they were coming up from Pennsylvania. That's not exactly, an intercontinental flight. So it's not a travel and hotel. I'll give you $5,000 for that, all in.
Okay.
So there's leftover, some fat left over. We got to get Doge looking into this. You don't work for us. No, was the answer. I've never asked you specific questions. Correct. So all of this supports the defense position that when we were told to hold off, we held off, and we did nothing else to connect with you, Mr. Independent expert. We didn't ask you for anything. We didn't direct you in any way. We didn't want to know your opinions at that time other than your report. We didn't go beyond that document, which both sides had.
Yeah, I see that there's an interesting point someone makes on X Twitter that, to be fair to the defense, the Commonwealth immediately said they were going to retry the case. Immediately, right? There wasn't even like a blip of a beat, like, let's go up to the office and talk about it. Let's talk to the jurors. Let me see if we have a case. They immediately, that if the defense plans to call these experts now, who are now let go by the federal government in trial 2, they better pay their invoice for trial 1, or else no one's coming to trial 2.
Yeah, that's true. That is true. And I do think there was a statement made about that phone call, the phone call to the Fed saying, hey, we just got this bill. What's the deal? Do we pay it? Do we not pay it? I am a little concerned that they paid it so quickly. I'm not sure what that tells me because they didn't solicit an invoice. I'm assuming they paid the entire invoice. They didn't get somebody haggling to get the price down. I don't know why they would have paid it so quickly just because the Feds say, yeah, well, we're done with them. Why don't you go ahead and pay it? I think there should have been more scrutiny if that was truly the first time they saw the invoice. And yet 2 days later, boom. That to me smells of kind of result-oriented paying. Whatever they did helped us. Let's not quibble over it. We may need them again, right? Because
because you're not going to. Let's face it. Yeah, if I am representing somebody and I get a great result, and then I send a bill and they don't pay me, and then they call me, oh, could you represent me in another case? What do you think my answer is going to be?
I know.
No,
I wish.
happen.
I'm going to have to get you into my bill collection department because I have a number of clients and I'll have repeat business with them, and they may have an outstanding balance, and I still represent them. I still go forward. I don't even leverage it like, well, things may not go so well if that bill doesn't get paid. But I understand the theory, especially with a high-powered expert type operation that these guys apparently
these are involved. Right, when they get hired by the FBI, they're not in usually some shady thing right now. But also, I'm worried about here's what I'm worried about. We had this whole week, and the judge with the grave concern, and what goes over social media is that somehow the defense team, and we talked about how people hate the defense attorneys, right? And it's kind of shifted with YSL, with Doug Weinstein, and with Joe Tacopino. Now we're getting back into, let's have the shady defense attorney. And Brennan's very smart. He's a defense attorney. He's very smart. Okay, he represented Whitey Bulger and stuff. He knows what's out there. I mean, he's a smart guy, and he's also a very good trial attorney, as we've seen in his questioning. But now the whole aura has been created about this may be a shady defense team that you can't understand or you can't follow or you can't trust what they're saying. And that's out there now for the potential jury pool. That's why this becomes important. And if the judge does anything and says anything such as, well, I felt misrepresented, I felt this, then that stays out there. And the jury pool now knows it. And I think that's a real disservice to Karen Reed for bringing this. Because if you knew that you had these documents and you said the defense didn't disclose them.
I tell you, in any other case, all things being equal, I would agree 100% with you because there'd be one more weight on the end of the teeter-totter to tip in the direction of the prosecution. This case, by public sentiment, social media, all the coverage you can imagine, is so pro Karen Reed. I'm not sure anything that's been done regarding this, confusion with the connection between the experts and the defense team is going to move the needle at all away from the defense that's out there for Karen Reed. Now, of course, there are a lot of folks who may not be that vocal, and they may be the ones that end up on the jury. Who knows? Doesn't bother me all that much unless you can prove to me that the prosecution had no good faith belief that this needed to be investigated. And I think that's what they raised, a good faith belief that we got to look into this. I don't think they were indicting or charging or convicting any of the defendants for doing something improper. They wanted
I don't know. I think you go to the defense team and say, did you know about this? All right, let's talk. I want to see what you have. And then if you want to show them, you get to show them. This is what we have. Okay?
Yeah.
They
And
showed
we don't know.
them. They sent it to them. Hey, let's go back. They sent it to them.
And so they are basically saying we don't believe it because
Right.
we
Because
now
what?
have these emails, and we now have this invoice that we didn't have before. So you got some splaining to do.
Well, why don't you just ask them for the splaining instead of making this in court? Why don't you just ask
maybe
them for
they
the
did.
splaining?
Maybe they did, and it got ugly, and they just said, let's just handle this in court. And
I
I also wonder, at the point where Judge Bev became gravely concerned, I would like to see how that played out, because it was material, as she said, presented to her by the Commonwealth.
Yeah.
Was that like, here, Judge in chambers, take a look at this stuff. Take a look.
No, I think the way it sounded this morning is that it turns out it was what happened in open court there. And
It wasn't so clear. If you're watching that hearing as we were last time, it wasn't all that clear to me that it was sort of an indictment as to something they did wrong.
Yeah, but now he's also going to go after. Now he's going to go after the experts. He's going to say, "You sat here and you testified that you were independent. You got paid, not you, but you got paid $23,900 and whatever it is dollars. There's $24,000. You're not independent at all because you knew that if you testified, you were planning to send the bill, didn't you, sir?" So then he crashed out on the experts. This is what's going to go on here. I mean, you and I both know it.
Oh yeah. Yeah, there's no doubt about it. And we also know that the experts are going to testify if either side wants them to. That is not going to change with the outcome in this hearing. So there's going to be more ammunition, perhaps, for the cross-examination of these witnesses, but they'll still testify.
Yeah, and let's go back to the word proctor has not been mentioned at all in this, because and that's what I think our viewers are complaining about. Okay, you have so much going on with the prosecution. Proctor and those emails and the red solo cups and the collection and the inversion of the videos and all this type of stuff. And that's, and the tapes being missing. That's okay. They can't give you to what they don't have. They say they don't have it. That's it. But there's no investigation as to why they don't have it. There's no investigation of what happened there. But when the defense does anything, all of a sudden we're unethical, and we spend days, instead of the defense being able to prep for their trial, which is kind of important. They're sitting here in Massachusetts for almost a whole month on these stupid hearings. Stupid hearings.
Yeah, I don't disagree with you there that there's a better way to use the time. There's no doubt about that. And if you look at the relative scrutiny, I'll call it, of the defense versus the prosecution, yeah, it does seem a little bit one-sided to be focusing on something that, let's face it, isn't going to change the complexion of the case that much. I don't think any attorneys get removed. I don't think any witnesses getting removed. And there have been some major issues on the prosecution side that seem to just be kind of, like a little dandruff on the shoulders, brushed off.
Yeah,
right?
Yeah, that's what it seems like. And all. Have you gotten a chance to see if anything around the courthouse has changed? Are people like staying outside, or are there still these signs and all this stuff going on?
No, it's all still the same. And like I said, they're inside the clerk's office down in the basement area. They're hanging out in the lunchroom and sharing stories. I mean, they're all friends, so they talk about family and where's so and so. No, I haven't seen you in a while. It's a very interesting collection of supporters, and I never see anybody for the prosecution. Nobody ever decides to show up here and enter what would be quite the storm if you were to come in here with a sign or something that said, convict Karen Reed. That you may not do well.
Well, there's people that believe she should be convicted, that whether or not she did this intentionally or not. Because remember, the jury never reached the other counts of whether or not she, in some way, whether he got scared of her car, he fell backwards in the snow or whatever, died hypothermia, in some way caused his death. I mean, there are people who believe that she should be convicted.
Oh, yeah, there's no doubt about it. And obviously some of them were on the jury last time, since they were hung on at least the second count. Even if you believe all those anonymous juror affidavits saying they were unanimous on 1 and 3, They never got to any decision on any of the counts. So there had to be some discussion, and
Right.
both sides had to be represented there. So
Yeah.
hey,
Yes. Go
I
ahead.
got an idea. I just got an idea. Because I got to run and do some stuff, and you probably need a little break. How about if Missy reruns maybe something from earlier today on the setup? That
Okay. And then we'll be back.
we'll be back
Yeah.
in 10-15, give or take. Right.
I think our viewers could use a little 10-minute comfort break, maybe a 10-minute lunch break. We only give 10 minutes here on Justice Serve TV because we're going to be back in that courtroom. And when they go back in that courtroom, at least I'll be back while Michel Bryant is going to be staking out and doing some stuff outside the courtroom.
Yep.
Who traveled up to Canton 3 hours today after being on the show last night. So, you got to give him credit because then he's got to go back.
Yeah, just to drive. Just to drive. Yeah, maybe I should stay over.
And you got a trial tomorrow. You can't. Remember that?
Oh, that's right. Damn it. Okay. All right. Check in later.
All right. So we'll check in with all of you later. Missy, you're going to re-rack something for us, and we'll be back in about 10 minutes. Thanks all.
Even though Alan Jackson was there, as were the rest of the folks. And the questions were very simply, where do these folks come from? Where do these experts come from? Before we put them on the stand, I need to know this information. We'll learn, because there's about a 90-second clip of when that took place, what their position was at the time. And what causes the court concern now is the court has learned that there was maybe more connection between the defense and these, quote, independent experts than there really should have been. Right?
Actually, the court said she had grave concerns.
Grave concerns.
And not just a concern, grave concerns.
Shaking, in fact, as she was announcing her plan, which was to delay the hearing from last week to this week. So before we get too deep into it, I think it's important. Let's take a look at, let me pull this up here. This, again, is the hearing from June 10, 2024, and this was again right in the middle of the first Karen Reed trial. Of course, she is accused in the death of her then boyfriend, John O'Keefe. And I'm going to find it here somewhere. I'm sure I am. I seem to have the same issue every time I look for video, right? And I'm going to see if I can find it here. Hold on. I do have it. I'm sure I have it here. What I want to find out, too, is Linda, what are the possible remedies if, in fact, the court has these grave concerns? So what? I mean, what could happen, right?
Right. And not only that, not only what could happen, but why would she have the grave concerns? I mean, there's one thing to have a grave concern about an attorney, but there's another thing if you take drastic action against an attorney before a second trial, because the client has rights to a trial. The client
Sixth
has
Amendment rights for
right.
the counsel, all of that.
Right, all that.
Okay,
right.
here we go. Let's listen to this again. This was from June 10, 2024. This is David Yannetti telling the court what, if any, connection the defense team had with the ACA experts.
Regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Okay, so we're going to play that again. It's only 90 seconds. I'm going to stop it a couple of times.
Yeah, let's
because
stop
there are,
Regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor,
okay, a couple of things happening here. The court under Rule 14 has to be comfortable that the defense has provided what they need to the prosecution. It goes reciprocal. You know, either side has to do the same thing. And they've provided a summary of sorts. She's not sure that's enough, so she's asking for more from David Yannetti.
We've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
Okay, these experts did not arise from us. That could be 100% true. 100% true.
Right.
It's more about what happened after they arose.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
You got that? They could not. It was specifically ruled they could not chat with us prior to trial.
Prior to the trial, prior to the report.
What was that?
Was it prior to trial or prior to the report? Prior to trial?
Prior to trial. I will back it up just to make sure you understand what she's saying here. And he's saying,
pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So
before trial.
Can you play that again? Just one more little time at the very end.
Trial is the key.
And it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense.
Did you hear that?
No, I don't hear the word trial. I'm having trouble with the word trial.
Wow. Okay. Well, I can't help you with that. It's about as clear as I could possibly imagine.
Yeah.
It's definitely before trial. What other
shout
words?
Shout out to a new member, by the way.
Context?
Shout out to a new member making account.
Great.
All right. Okay. So it was specifically ruled they could not have contact with us or chat. You say it's prior to trial.
I think he might even say check with us. I think that's the
check with us,
CH
not
word.
chat, or check with us prior to trial. Okay. All right. It goes to show you. It goes to show you how different people hear different things, and when you have a transcript, you say, "Oh yeah, that's the word. That's the word."
And to that point, the judge has required that the counsel for the defense, share with the prosecution and bring today to this hearing a transcript of this 90-some seconds we've been listening to. Okay, let's continue here.
Yeah, everyone agrees with you that it said trial. Sue said
everybody said okay. All right.
Defense is calling 3 witnesses that you've never spoken to and putting them on the stand here when.
Okay, 3 witnesses you've never spoken to. Now, maybe they had emails. Is that spoken to? I think you have to assume that spoken to in this context from the judge means contact of some sort that goes beyond what's your name, rank and serial number. What do you think?
Well, it's spoken to in terms of maybe the substance of the report. I'm not sure it means in terms of how you get to the courthouse, whether your fees are going to be paid to get there, whether this travel is going to be paid. I'm not sure it means that. I'm not sure she asked the right questions, because I remember the defense turned over this. We're in this situation because they turned it over. So if they thought they did anything wrong, I don't think they would have turned this over.
That's possible. Let's hear what Yannetti says to this follow-up from the judge.
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Okay, coordination of their testimony and their background. That is pretty clear. There is no suggestion in that response that they spoke about the substance of the report or how it may or may not help the defense. Would you agree with that?
Right. But I agree with that. But the question is going to be, what did he say? Spoken to with regard to the, go backwards. Go back a second.
Hold on.
Coordination of their testimony.
Yes, hold on. Here we go.
And that's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Okay. So this coordination of testimony, what does that mean? Does that mean did they charge a fee? Does that mean that somebody gets reimbursed? Does that mean that
or is that just scheduling?
Or is that just
scheduling?
It's just coordination of testimony.
I guarantee you, these are the words they're going to be mincing up. Okay, let's continue.
We have not been able to interview them regarding their findings, which are.
We have not been able to interview them regarding their findings. Now that's substantive.
Right, and I believe that I believe that's going to be the situation. That's going to come down. They weren't able to interview regarding their findings, but they were able to interview regarding coordination of their testimony. So what does that mean? This is where it all comes a little hazy, right?
I think you can argue either way, but my gut tells me you're just past the 50-50 line in terms of being a little bit vague, and maybe purposely so that if you get caught down the road, you can make these arguments. I think he is close to unequivocal about talking to them about substance.
Or what we're talking about with that 24,000, it's a little under 24,000 billing issue occurred after Mr. Yannetti talks to the court. What is it? What was the date of this hearing here that we have?
This was June 10, right in the middle of trial, June 10 last year.
Okay, and I have to do a calendar as to when the experts, and our chat can do this, when the ACA experts testified. And the question is going to be then, when were the emails and the billing? Is it between June 10th and when they testified?
Yeah, it definitely soon after this because they did a voir dire of those experts, and that took place before they testified. So it was in pretty rapid succession. Let's continue on here, see what else we can get out of this.
In detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor.
Okay, here
we are. I'm back. I tried unmuting myself, but I want to put some comments back up as we wait for people to have Afton. Afton has been with us for a long time. Do you think they get to use testimony from the previous trial for impeachment? Yes, of course they will. Believe it or not, they'll have it word for word for impeachment in case somebody gets on the stand and says something differently. No doubt about it, which means this trial will take twice as long, if not 3 times as long, because I also think that Hank Brennan also is going to be a lot longer as a prosecution prosecutor, main prosecutor, than was the previous prosecutor. So let me ask, Idiot One, thank you for supporting us so much. Really appreciate it. Just constant with us. Let me see if I can read this from afar. The phone call with the evidence, the phone call with all the evidence of acting within the rules in what can be established by evidence. I think the customary assumption of candor towards attorneys is restored, so you can accept no substance in. Is that the call at the very end? This is what happens when your eyes don't see far, because I have my reading glasses on. So I am going, but let me, the candor, I think that's the problem she's having. She thinks that, you should tell the court everything when you're a defense attorney. Well, a lot of times you don't necessarily tell the court everything. Yes, that is a phone there. You don't necessarily tell the court everything when you're a defense attorney, especially when it's not asked. I mean, oh, Judge, but let me know. There was these emails here, these 2 emails where it was paused, because your view at that point is, well, nothing. There was nothing. I mean, he made contact. I was going to retain him. Whatever they wanted that retainer to expand. We never got to talking about it because maybe I couldn't pay him for his fees, but maybe it was for his travel expenses. So I'm sure the judge is going to want to see that retainer that was forwarded if it's not there already, if it's not in the packet already. And the question about the phone call is, does she put Alan Jackson on the phone or ask for an affidavit from him saying that what was represented to the court by Alessi was really the call? Well, I'm not sure she's going to do that at this point. And then thank you again. You have another question. Thank you so much again for your donation to Justice Serve TV. I also think that after all this, it is Brennan's reckless impugning of the ethics and candor of another attorney that calls for sanctions. I think that it is reckless. And I'm not sure that it's reckless as so much as it was planned to be that way. I know Michel Bryant has a different view. I just think that you have to know, you're the prosecutor, you're the state's attorney, you're the Commonwealth. You have all these people. I've tried Aaron Hernandez against it. They have investigators, they have police, they have all these people in the office, they have the first assistants, second assistants, they have teams, they have everything. You can't tell me that somebody didn't know that you had these documents 5 days before from the U.S. from the U.S. attorney, from the defense. It wasn't from the U.S. attorney's office. So when you get up there and you say, even in a moment, and say, well, we had to get them from from the feds. We didn't get them from the defense. And then you kind of walk back to the turn and you say, no, we got them from the defense. But you know that the word is going to spread that you're impugning, and you're still impugning, right? You're still impugning, and Judge Bev is impugning by doing this in a different way, because she's worried about the veracity to the court. We see everybody's in the courtroom. Why don't we go into court and listen? And we'll be back with you, as most of the day it's going to take. We hadn't planned it this way, but we're here for you. Thank you very much. Let's go into court.
May it please the court, I first want to thank Your Honor for the generous amount of time you're according to me.
No need to thank me. Go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response, in quotes, "Hi, Alan, substance to our conversation. On Wednesday, the U.S. attorneys," and he's quoting purporting to quote the, and it's good to have it, Your Honor, can be having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, etc., etc. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58. And this is where I left off. Line 2, now this is information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications, that's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th.
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get something wrong, but I want to try my best to get it. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
Okay.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And what
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get
Judge,
that.
if we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry?
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed-ARCA Reciprocal Discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA Reciprocal Discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So Your Honor, appropriately and understandably, says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you. Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah.
Subject-
So that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What is
So-
the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The
When
other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's act wolf_quals document. Okay? So there's 2 emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says in the title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
Wait,
just
actually,
went.
hold that thought. I just have one other thought about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, and what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
and you are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, but blah, 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 blah. Now, here's the next one.
Another comment. He's quoting, would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree, it would have been, and you did. Twice. Next. Reading on the same page 16, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. In the direct it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point at the. No, let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2. And then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I Attorney Brennan, didn't know any of this. But I've tried a few cases, I've been around the federal court a bit, I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried among several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, it creates blah, 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 and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts, we're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpreted it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that was based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court staying a break, is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case? Or
No,
are
I'm
you
talking-
saying generally, you've had this issue in other cases, or do you mean?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break, so we didn't get an opportunity to stand up and say, you know, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information, and I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant, but Your Honor well knows what Your Honor said, but it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will still be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key, so you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14, what was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything, but.
I don't understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you've got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this. Being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth for the fourth time has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got. Because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize your honors giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up
Again,
some...
you don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the notebook. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs if Your Honor feels differently based upon what I've said, or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Buchalter, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give the Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14, and so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on the court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances in this. The case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements of fact about the financial statements. And then the question became, did she knowingly know it? And what the court did, and she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the only, the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate. All completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, etc., etc. And what does that relate to? If Your Honor would go back to page 60, line 13. and it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry, okay. So, my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So, I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
Counsel pro hoc vice, or is that not?
I'm going to get to that. The answer is the counsel. I want to be assured my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding. Government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not, for the trial, the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument, I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties, and I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
You are muted.
So there you have it. That's the end of Mr. Alessi's argument. I have a couple of notes, but first I want to ask a couple of questions, answer a couple of questions here. Idiot wins. What does it matter if the counsel, if that counsel was pro hoc vice, if this lawyer in question hasn't committed an ethics violation? It's kind of the same question that law nerd Amber asked. Why does pro hoc matter? Because to us, don't ethics apply no matter what? Okay, so here's the issue with this whole pro hoc issue. To get into pro hoc vice into a state, you have to show that you are of high ethical regard. There was actually a case in New Jersey like 50 years ago by famed lawyer F. Lee Bailey. And he had gotten all sorts of acquittals, was on the top of his game. He came to New Jersey, and they booted his pro hoc for misrepresentation or something to the court. And then my partner, actually, a person who became my partner, Robert Ansell, came in to represent the defendant in that case. It's an extreme thing when you're pro hoc to revoke a pro hoc, as opposed to admit. Once you're admitted, you're assumed to be of high moral and ethical standing, and you had to prove that. To kind of you show your values, you show the fact that you're in good standing. But to revoke it may be a higher standard, okay? And that's why she asked those cases, was that a revocation, or was that the acceptance in? Was that the granting in of the pro hoc vice for those cases, or was that a revocation? Because she's already made a finding, or somebody's made a finding, that he has no claims against him. He's have ethical value that he could practice in another state. I've had this done a number of times. I've been in Florida, I've been in Connecticut, I've been in Tennessee, I've been in Massachusetts, I've been in California, just off the top of my head. Those are 5 states I can think of where I've had to go pro hoc vice to defend the client. So, and you're also taking away from the client, right? So, but the fact that she's even asking those questions really bothers me, in light of the fact that we know that Mr. Alessi felt he had to address it. Now, after lunch, what did he address? And I'll try to go through this quick before she comes back, okay? He did admit that that prior to trial, the witness showing, giving an outline of questions, right? And there were 2 emails prior to if I recall, 2 emails early on. That was the one email that Jackson sent a retainer agreement to the witness and said, we'll have to, see if we get you retained. We'll have to talk about this. It was never assigned, because then there's a second email that there's been a pause put on this by Jackson, by the U.S. Attorney's Office, that they don't want anything to go forward at this point with regard to that. And then there was another email later on that wasn't disclosed. In my opinion, quite frankly, a bullshit email. Okay, let's get down to it, where the witness sends an outline of his testimony that's never used. It's never used. Jackson goes somewhere different, and also then sends his qualifications, his CV. So what? You can get that online. So what? So they're talking about the outline, and the judge asked specifically, was it disclosed prior to the witness's testimony? And unless he answers honestly, he says no. He has a duty of candor with the court. So what Alessi's trying to narrow this down to is that all we have here, then, Your Honor, is we don't have any ethics issues about constant misrepresentation to the court. We don't have that. That's where these revocations come in. And Yannetti, when he was making his representation to the court, wasn't even aware of any of this stuff going on in the background. But what you may have at most is a Rule 14 discovery violation. And what's the remedy for that? Since we're starting a new trial, there's no harm, no foul. Besides, I would argue that the Commonwealth, that he didn't get into this, but the Commonwealth had so many discovery violations, right? We saw things not being turned over, claims that things weren't being turned over and then turned over. And then, so then the other thing, Michel Bryant and I talked about this just before we came on the air. If you have a problem, right? If you think there's you call the other attorney and you say, hey, we think you got something else. And what Alessi says is that, look, we were completely blindsided here. You didn't call and say it was and we'd look and we'd see and we'd talk about it. Maybe we'd come to some agreement like we did with you and the fact that there's no tape from the car, that's available and going into the garage and out of the garage that should be existed. That we only have very, very little snippets, right? But that what you've done is that you've now created a whole thing for the jury pool to get out there, that you've not only is Karen Reed worried that her experts are going to be barred as some form of sanction, and that her attorney is going to be sent packing back to California as some form of sanction, but the jury pool, everybody out there now has aspersions, believing that the defense team and the people that are going to testify are somehow not exactly ethical. And that's what you've done. And what he said basically is he's saying that this is it was done purposely. It was done with this in mind. He's basically saying, by the way, there's 10 misrepresentations to get to this point that the Commonwealth had to make. But we can go through all those 10 misrepresentations, but because you're not doing the same standard with them as you're doing with us. But why don't we just move forward? But what he's done is given the judge, who may have been thinking of sending AJ packing, even though there's a Sixth Amendment issue, a big Sixth Amendment issue that could possibly get reversed here, but instead giving her the opportunity, if she wants to do something, because it appears like she wants to do something, right? It appears that she's biased against the defense and she wants to do something. That's what it appears to all of us, right? Is that she can find that there's a Rule 14 discovery violation, give a slap on the wrist, whatever you want to do, and then go on with the trial and everything goes forward. But, the fact that this hearing was set for a full hearing, that she wanted, that, Alan Jackson came in for it, the fact that we've already spent all this time, we haven't even heard Brennan, the prosecution, talk, and we haven't heard any rebuttal to that. And of course, I doubt she's going to have a decision today, probably tomorrow, the way things are going. Tells you that this was being taken seriously, that she had grave concerns, but the representations weren't there. There was no massive discovery violation because the discovery from the feds, the prosecution had, or they could have gotten by picking up the phone. The things that we all have. Where's my phone? I have over there's this thing, hello phone. Hello, U.S. attorney. Hello. Do I have everything? Because I think the defense called you, right? Whatever, or, what you're really pissed off about here, if you're the prosecutor, that ARCA for the federal government came in and they substantiated what the two medical examiners from the state had said, that there was simply no way that you could conclude that a truck hit John O'Keefe, that the SUV hit John O'Keefe and caused his death. And that's what they came in and did. And they were independent. It's an independent report. So now what you're trying to do is show that they're not independent if you're the prosecution, and you're trying to convict her by doing this. And that's why this took so long for Mr. Alessi to lay out not only this, but it goes to Alan Jackson's reputation. Now, I know Alan very well. He's a hard litigator. He's not going to sit there and do things unethical. All right. He's gonna be hard. And it gets to me, for all of you that are concerned, why is somebody like Mrs. Love, we saw in YSL, get to practice with all those discovery violations and no problem, or the prosecution that was in YSL, the first team, not the second team that came in that even Doug Weinstein liked, right? Why does somebody like John Lewin get to yell at the judge, where the judge has to tell him to sit down and shut up, basically, and he gets no sanctions? And here, what we're talking about at most is a couple of emails that didn't affect anything, right? And they want to boot AJ because of a grave concern, having the aura of an ethical violation. Well, Alan Jackson, I'm here to tell you that you and I tried Spector together. We tried it hard together, but I'm in your corner on this. I'm in your absolute corner on this. Your pro hoc should not be revoked. Your client should not be hurt by this. And quite frankly, now you're going to need a really big jury question, right? You're going to need a really big jury questionnaire to sort out all the people that may be biased against defense attorneys to begin with again, and then sort out this. And I'll tell you a story when I was in, and I think I mentioned it with Michelle Ward, Dr. Ward, who was on the other night in Tennessee when I was picking a jury on a pro bono case. The questionnaire said, "What do you think of defense attorneys?" And the answer came back, "They're only doing their job to convict to represent the person we're going to convict anyway." All right. So now you have that hurdle to go through. So I want to thank here. We had Nancy Moo 12. Thank you for your donation. If YNW Melly gets to keep his lawyer and she's under investigation for witness tampering and putting a hit out on a witness, KR should be able to keep AJ. That's a pretty good analysis, isn't it? Of course, why is she under investigation? That becomes something that we all wonder. Defense attorneys are always they're always under investigation. If they do something, they're always doing something wrong. And this is, we just discussed, we thought this was changing, but this is not changing. And what's scary is Mr. Brennan, he's a defense attorney. He represented the mob, Whitey Bulger, one of the people that killed a lot of people, was on the run from the feds for a long time. Let me tell you, he knows how to pick up the phone and call the federal government. He represented Whitey Bulger. He was in a courtroom with the feds. That's just what he does. He goes after the government. He goes after the government all the time. So you mean he couldn't pick up the phone? Hello, U.S. Attorney. I just want to be checking here. Now, Hank Brennan's a really good attorney, and that's the point. Really good attorneys pick up the phone. Really good attorneys call the other side, and they don't blindside. They say, we're going to go after you. We may go after you. Okay, we may do this, but they give you at least an advance warning. Usually. So, and I think there's a lot of concern here, and you heard it with Alessi about whether or not they are going to boot Alan from the case. Well, Alan, we're here to tell you that the defense bar is all for you on this. I'm a member of the defense bar, as you know, but I've been a prosecutor. I would never seek a revocation of this just because I didn't get some discovery. When I don't get discovery from prosecutors all the time. Did you hear all Luigi Mangione's attorneys the other day? She said she learned about discovery that they're not getting in New York. And New York is always a tough place to get discovery. Let me tell you, you never used to get it until after the jury was opened, until about 6 years ago when they changed the law. You all can't believe that, can you? But she said that she's hearing HBO interviews. She's hearing Eric Adams and other people interviewing on HBO and giving facts about things they have that she hasn't gotten in discovery to represent her client. So why aren't the attorneys under investigation there? I mean, you just say to yourself, where is the quality in all this, and why is it that we have to pay? And I'm sure the judge was concerned, because the way Mr. Brennan make it sound is that all this was not being given over by the defense, but it not only was it, you had access to it by yourself. You had access to it. This was not a witness that was hired by the defense. This was not a witness whose reports were the inception of them was the defense. It was the FBI doing an investigation into a bunch of things happening in that area with those police departments, and also Karen Reed. This was a bunch of stuff going on. It was so the defense, as a matter of fact, they just kind of fell into getting these reports. They didn't have these reports beforehand. And now, you see the prosecution also, the defense has motions to knock out, we talked about it, a witness, a weatherman who wants to talk about the ground being hard in January and all. Now we're, now we're into, I guess it's Bob Dylan. Well, can you all look up the weatherman, with Wind Blows and the weatherman song? Let's look up, let's see if we can find some lyrics to talk about that, since we're now, obviously Bob Dylan has entered his trial with the weatherman. Okay. So, Idiot Win says, the change may be amongst some of the general public, but the change is not even approaching in the judiciary. You're absolutely right. They still accept faulty forensic science. New York State accepts bite mark evidence, okay? Like people bite mark evidence. Now you're not just talking about dog bite mark evidence, whereas most of the rest of the states have disregarded it and said it's bad. Full eyewitness identification, we know, is bad. Cross-racial eyewitness identification, we know, has got a problem. We know the whole idea of bullet matching that we talked about in the A$AP Rocky case, that has a bunch of problems. But the judges on the bench, they're willing to accept that. But if the defense comes forward with an expert, the scrutiny the defense expert get is really back. So court is coming back. Yes, thank you, Prince Lever. Let's go in and let's listen.
So before I hear from the Commonwealth, Mr. Lesson, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do is you said I could ask questions of other counsel. So while memories are fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Unetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
What he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript. I did as well after I looked at the transcript.
I did long before I looked at the transcript.
Right. the context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment?
No, nothing. Because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the...
Nope, hold on. Ms. Little, it's just thrown on you that you're, that you're responsible for all discovery, but the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. It's information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them, and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Lisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Lisi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. How the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information when you compare it to the representations that have been made prior to trial by the defense that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vitae. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vitae attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully to Attorney Yannetti, a fine attorney, an excellent attorney who I admire, but there is a responsibility so that there are not a number of pro hoc vitae lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've done.
May I have a moment to speak to counsel?
Sure.
Thank you, Ron.
I'll need to call the United States Attorney's Office and get an answer for
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26 of
No, I
trial.
know that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report, he's got the report, that's it. I'm going to start asking questions on the report, that's it. He can cross the report, so as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report, and those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's day, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts in ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second. Let me go with that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024. The voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face-to-face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with their representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. It's addressed to...
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson, and the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. Our experts knew, Dr. Wolf knew, Dr. Rentschler apparently knew, the federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communication because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support or put in context the conversation. Nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when we look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, self-promotion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asked Mr. Jackson about paying the bill. And what I suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have the trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did
Any
the
particular page you'd like to read without citing?
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Rentschler, and Mr. Klein, says essentially the same thing. So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there's no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline. It's the fact that they have the relationship Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the ARC experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelling. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That's a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it, we don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony?
Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
Nope.
have to go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
And let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses, because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Yannetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Bryant didn't read the rest of it. You're to believe...
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response, and it's total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because I
read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3a1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3a. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Bryant?
Very briefly. My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading,
That was filed
On
late, right? The
February
first
6th.
Saturday or something?
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Minetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has only done a
Maybe
certificate of
authored
service.
by it? Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Minetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Danny Wolf, PhD, and Andrew Rentler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retain, but that retain word has import because it wasn't he said. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
What line, please?
And there you kind of have it. That's the wrap up of the hearing. Hi, even Judge Beverly Cannone was just tired of hearing the prosecutor. So why don't we go through it? Let's give it, first of all, on the, I don't know if you're going to call it a rebuttal to the prosecutor. I would tell you that Mr. Alessi came back on fire, didn't he? Right? I mean, I thought it was afternoon. We talked, but we could talk about a little bit about his afternoon session. But, you know, I think we went over most of it. I thought what was interesting, the judge did something that I thought she would do by affidavit, but she asked Mr. Yannetti, she asked him to stand up and said, is everything that counsel represented true? And he said yes, and talking about Mr. Alessi. And then asked AJ to sit up and said, is everything true? And then Alan Jackson said, when that sidebar occurred, and the judge clearly knew the sidebars, you know, word for word, I did not have in my head the emails because the question and all the discussion was around the TUI request, which happened to do with ARCA and the reports and the 3,000 documents that they all wanted to get. And I understand that. I mean, that's because that's what was serious in this case. That's what's the meat of this case. And I will still say to you, my view of this case, even listening more to Mr. Brennan right now, and you know, I give you my opinion, good, bad, or indifferent, is that the Commonwealth is tainting that jury pool out there, thinking defense attorneys are liars, thinking that Karen Reed hires defense attorneys as liars. And then when ARCA gets on, they're going to be questioned about their ethics and their billing and all sorts of stuff. Because why? Because the prosecution didn't win the case last time out. This is a big deal for them. That's why they went out and hired a special prosecutor who represented Whitey Bulger, who is actually a defense attorney. So let's go. When Mr. Brennan got up, he said that a couple of things that I want to discuss. He said, I am talking about the relationship that wasn't there seems to be a relationship between ARCA and the defense that we don't know about. A relationship, right? You know, maybe the relationship is just one forged of they're going to testify to them, and the testimony is going to be valuable to their client, Karen Reed, and not valuable to the state. So ARCA was not expecting to be called by the state. I doubt they were expecting to be called by the state. All right. So that was one of the things. But he's worried about the relationship. Maybe there hasn't been full disclosure. And he speculated. Maybe there's other phone calls. Maybe there's other emails. Maybe there's conference calls. Maybe there's this. Maybe there's that. The judge had told everyone not to speculate. And then he speculated too. And so he said, I was worried about the ex parte communications. At one point, though, the judge did kind of like, I felt that she wasn't giving him as much leeway as she had when he first made the argument. And I was wondering whether maybe she thinks that this is a lot of much ado about nothing now, that she's going to find something, because she has to save face. Remember, she just spent a whole day on a hearing, and obviously her opinion is not coming out today, probably tomorrow, because she said to all the attorneys, I will see you back Tuesday and Wednesday next week at 9. And remember, they're planning for a retrial April 1st. They're planning for a retrial, right? At 9. I'll send you Tuesday and Wednesday at 9, and all the attorneys to come back. Now, if she's going to pull a pro hoc vice, I doubt that she would say that, or maybe she would, just because she has no reason not to. And the other thing she could do is she could say at the very end, look, I've heard all this. I will take this under advisement, and I'll have a decision for you at the end of the case as to if there's going to be any type of sanctions. If I find any sanctions, I find anything, and I'll review it then. Kind of like, we heard Judge Arnold and ASAP Rocky, 15 under 15, and I'll deal with it at the end of the case. I don't know if he ever did or ever will, and all. But the other thing that Brennan said, if you know, that he got under the thing is, I am concerned that if this kind of, and he didn't use the word unethical, but this kind of behavior continues, that there's no control on it for future misbehavior. And those are, I'm paraphrasing here because I'm not going to repeat everything he said. I'm just not going to do it. It's just too much. I'm paraphrasing it. And you haven't even proven any misconduct to begin with. You've got a lot of aspersions now, and you've got a lot of people wondering about them, and you've put Karen Reed's attorneys in the limelight, and you've taken their good name and reputation. And at one point he even says, oh, I have no problem with Mr. Yannetti from Massachusetts here. He's a wonderful attorney. But you put him under the spectrum of possibly he's with all these out-of-state attorneys that are terrible, that are like, boo, they're ghosts, And I think at one point, if I can find the words that were used, and you probably have all written them down too, ghosts, unless he said, what the prosecution has done here is talked about ghost illusions, and I can't read my own writing. Ghost illusions and something else that began with an S, right? What was that? Ghost illusions and something else. But that they're creating the spectacle that doesn't exist. And they've done a good job of it, right? We just spent a whole day on something that may not matter. We have just caused Karen Reed's experts to come under, she didn't bring them in and say, what was your expectation, right? Bring the U.S. attorney in. What was your, see if he'll come in voluntarily on the phone. Maybe he won't. What was the phone call about? What was the expectation? If they had no expectation of getting paid, but they had to justify in a big firm, I've got to justify, and you do this in a big firm, you justify, you do it in a little firm. When I'm on a case, I'm writing down, I may never get paid. Many of my cases are pro bono, but 1/10 of an hour for a phone call, 5/10 of an hour and you put it into your billing folder and you're in your billing program, and you see what you're doing. You see where your time is being spent for the last month or the 2 months or 2 weeks or whatever. Certainly, I mean, that's the normal business world out there. If you're representing big clients, sometimes you may get a fee. Like Mr. Brennan may have gotten a fee that is a set fee for representing somebody. But if you're not doing that, if you're in the business world, you have to justify your time. Even when I'm representing civil clients and that may have a corporation and we're defending a case, I will say, look, they should all have their time by hours, how much time they spend on this, because when time comes to whether or not you're going to settle this, you want to see how much your staff is spending on defending this case. And you may want to make a business judgment that you're going to pay it because it's just too costly to continue it for uncertainty. So, I mean, but all these things now are getting thrown out, and apparently social media is going crazy and all. I know Michel Bryant is out there in front of the courthouse trying to rein some interviews in, because apparently it's really crazy out there right now. Let's see what he said. Again, the judge did ask also, Mr. This is the other thing. Mr. Brennan brought in the fact that apparently AJ was asked. They said he said, and he apparently misrepresented this. AJ was asked by a reporter, "Did you pay for the testimony and all?" And then he answered no, but he really did pay. But the question was a little bit different, and that's the game. Experts come in, your testimony is paid for. No, your time is being paid for. When all of you go to your doctor's office, does the doctor expect to get paid? Yes. When you go buy a coat at a store, do you expect to pay the coat? Yes. When you get gas for your car, do you expect to pay them? Yes. You expect everybody gets paid for what they do, right? Does the saleswoman tell you look nice? Salesperson tell you look nice in that coat because they want to sell it? Maybe. Now somebody asked the question: is it normal for the federal court to get them in so quickly? Okay. Remember, there's been this investigation that's apparently been going on, and that we don't have access to, but the attorneys may have some access to. So that's what's happening. And when that becomes open and we know about it, we may know. But this case has been going on now, not just for the 6 months we're seeing it. It's been going, or the year we're going to be seeing it by the time we're finished. But it's been going on since John O'Keefe apparently died, somewhere soon thereafter. And you have the companion federal investigation that was going on in the Birchmore case. Now, given the new Department of Justice and investigations being looked at and changed, and gosh knows what's happening there, but that's what it said. Nancy Mood 12 said she's dying to get rid of AJ, but with them in federal court next week and the trial starting in 5 weeks, she needs to be really careful. I thought that the vet here, when I first started, she definitely was going after Jackson, especially with the question about the revoking of the pro hoc. But I don't see anything here to revoke. I don't see any reason to revoke. I don't see any violation of the ethics. What Brendan's trying to say is, well, the aura they created is that, and this is a big complaint, they're independent experts. Yes, they're independent. They were paid for by the government. The feds paid for, and I'll guarantee you it's a lot more than $24,000 for 3 people to do their job, to come to a report because they're running a federal investigation. Okay. Yes, they were independent. Yes, their conclusions were independent. Yes, they never even spoke to the defense before they came to those conclusions. And this is where I tell you, the judge did call Brennan out. Brennan said their testimony changed between the report and all, right? And she said, well, where did it change? And he went trying to look for something. Point number 4. Yeah, but we didn't hear where anything changed. And if you heard it change, believe me, if there was a difference in their report from what they testified at trial, the first prosecutor, he wasn't an idiot. He was still a prosecutor. He knew how to cross-examine. He knew how to impeach credibility. He would have called that out. The end result is the conclusion of what they were hired for is to see whether John O'Keefe died because of an SUV impact, and they concluded he didn't. And it supported the two medical examiners from the state who said there was no evidence. He didn't. So, I don't know. I guess they feel that the ARCA experts, the state feels the ARCA experts are really hurting them, which they are. They felt the dog bite expert really hurt them, which she did. And so they want to get rid of all of Karen Reed's defense. And all of you are going to ask me, isn't the job of the prosecutor to bring justice, to seek the truth? Yes, but the problem is prosecutors, and we've seen it recently, believe that seeking the truth and getting justice is getting a conviction. And Joe Tacopino, in his closing in ASAP Rocky, started to go there, and there was an objection to it, and it was sustained. Win at all costs, all right? Now, is this prosecutor doing that? I don't know. But there is a feeling out there, certainly from the defense board, certainly from a lot of people now watching, that there's a win at all costs, that the courts are not seeking justice, and that things that the defense does are blown out of proportion. We saw two exceptions to that recently. We saw Alec Baldwin, where the judge said, hey, you violated Brady. This is it. You violated Brady. You're out of here. And we also saw a pretty fair judge in Arnold, right? Mark Arnold, with ASAP Rocky. He was, woo. But, I hear a beep in my ear, and that can only mean one thing. There he is, Michel Bryant. Okay, we have been discussing and watching and listening to all afternoon while you have been on the road in Canton up there in Canton.
Yes.
What do you have to report?
Melee, I'll tell you one thing. As everybody left the courtroom, and they left the building separately, it was Alessi, Alan Jackson just ahead of him, but Karen Reed left a few minutes later on her own and kind of to the other direction. She was with Yannetti, but so not a big united front as they usually are. But here's what I found most interesting. Alessi wouldn't answer a question. Jackson wouldn't answer a question. These folks are usually a little chatty on the way in and out of the courtroom. Said nothing, which to me says this is a little bit serious. Okay, regardless of what they believe the facts are, what the court should rule, it's up in the air, and it's a question that could affect them very directly, and more importantly, their client very directly. Right. Now, when Karen Reed left, chatty as she might always be, and Yannetti did say that he thought Mr. Alessi did a great job. Alessi wouldn't answer that question when I asked him. I said, how do you think it went today? And it was, the guy is kind of like a dual personality. You see this very articulate and confident, for the most part, orator, right, when he's advocating, but otherwise he's kind of a mousy little guy, and I say that as a mousy little guy. So
you got great presence.
So that was interesting, I thought. But Karen Reed was asked by somebody in the scrum, and this was a painful scrum. I ran into a telephone pole.
Wow.
She was asked about, what happens if one of her attorneys is removed, obviously Alan Jackson. She said, I think she was asked, what does that mean? And she says, appeal. So she's already been, conditioned to the what ifs in this case. And if one of her attorneys, Alan Jackson, were to be removed, she knows that it has some impact down the road, obviously well after this trial. So what are your thoughts as we heard from Brennan? And I guess, to be clear, I believe they're done with the issue now. She led a lot of back and forth. They should be done with the issue. So we could get a decision on this in the next day or so. Right. And I think she'll want to clear that plate before next week's full-throated motion to dismiss, as well as the federal matter, which is going to be Wednesday morning. You heard the judge, I think, tell the attorneys, go see the feds first, and then join us here. And that'll be for Wednesday. But Tuesday will be a normal court day here with a number of motions still up in the air. So, again, what'd you think?
Well, I think, first of all, you heard me say, I think Alessi gave her a way out to say, look, you had a discovery violation, and what I'll do is I'll decide after this trial, and that keeps the ball in the air, afterwards about what I'm going to do about it. But right now we're going forward with this trial as is, and that you prosecutors, you have all the information. You can cross-examine on those emails. If there's any more, the defense has to turn them over to you. but you can cross any emails, any communications you had with ARCA. So there you go. No harm, no prejudice for this trial. And that way she keeps the ball over the head of everybody, you know, could I smack you on the hands? You know, I think that for her to remove, she has researched this issue because she did ask the question about, isn't there a difference between admission and revocation of a pro hoc vice, right? And that was a pretty big question. And whoa, they liked that question too. They thought that was a pretty big question also. So I don't think she's going to remove Alan Jackson. I just think that
I don't think so either.
Problems, right?
But I do agree with. Please, patience, Matt. I do agree with the thought that hanging this out there like they did, especially with the judge's grave concerns. I mean, that truly went viral, and that has a negative impact, no matter what the ultimate decision is by the court. So I think the judge has to be careful, you know, however she handles this after her grave concerns. I think Brendan made a couple of very good points. One of them being he kept pounding away on there has to be something more. There must be something more, something we're missing, because between these emails and this invoice, you're telling me no conversations, no communications of any kind took place between anybody on the defense team and these experts, that invoices was generated out of whole cloth. If nothing else, the question's hanging in the air, and it's not an unreasonable question.
Yeah, but here's the problem I have. They have the invoice, right? So if there's a line item, there's only one call with Alan Jackson that they mentioned, right? If there's the line items, it would show the communications. And Brennan complained about the one call we don't know was said with that one call.
That's
but we don't even know how much. Was it 1 minute? Was it 2 minutes? Was it see you in court? You know, blah blah blah. And that's the, you know, and the judge could have asked AJ about that, right? She could have put him under oath and asked him.
She did ask all the attorneys if they had anything to say that would be contradictory to what Alessi had argued, but they all said no, we agree. And Alan Jackson had a little clarification. My point is, it's still hanging in the air. We don't know how long the phone conversation was. We don't have the billing detail in front of us. I think if it had been a longer call, it would have been highlighted perhaps by Brennan. But we don't know. How long does it take to say, look, it'd be great if you focused on A, B, and C. What, I just did that in 8 seconds. So you have a minute phone call. It could be damning if it's the right subject in that phone call. We just don't know. And I think to leave that question out there was a good move by Brennan.
And then he'll attack at a trial. But I think what's happened here now is here's where the prosecution became effective. And this is where I disagree with. They have now, in a way, taken the ARCA experts, which were paid by the government. You heard Alessi say, wait a second, they were paid by the government, they were paid by the government, they were paid by the government, they were paid by the government at the very end, right? And that's what they're going to say at trial, obviously, that their reports are still independent, they were paid by the government. But you've taken them, put them under like a cloud, as Alessi said, of like ghosts, right? He didn't use the word goblins, but of ghosts, right? And the same with now Alan Jackson. You've taken it for the public view when you have this jury selection and putting them under a cloud, even if they don't deserve to be under that cloud.
Here's a question I don't think was answered. You keep saying, I think you said about 7 times, they paid for the feds paid for it. Well, the invoice in the end was paid for by the defense. So what was paid for at the time of retention by the feds? I don't know.
I'm sure that. And you may not be able to get that as a bill.
Of course. But my point is, it's undisputed that the defense paid $24,000, give or take.
After they testified. I think that was for them coming to trial and expressing their opinion.
Whatever. Right. We're speculating. We have no idea. But it would be so much cleaner for the defense if the feds paid for everything, that there wasn't a bill hanging out there that the defense paid for. And they did.
The contract had ended, so the feds weren't paying for anything after that.
And the question becomes, did this company just send out the invoice hoping for the best? Or were they prompted to do so in the shortest of phone calls, in the shortest of communications that are not documented? We don't know.
I think if it's the way that Alessi says it, what clearly happened to me is that the defense thought that the feds were paying for them all, right? And then somehow the contract ended, and then and everyone decided that the experts say, hey, wait a second, we're not being paid for by the feds either. We got to bill somebody for this time, right? We just testified, and they sent out a bill of Jackson, who they testified to her, and they say, what's this?
That's what bothered me a little bit, was the rapidity. That means fast. how fast they paid that bill. You know, they got the
was
bill.
it 2 weeks or no?
No, 2 days.
2 days.
They made the call. It was confirmed by the feds that, yeah, that's legit. However, they did that. And then they wrote the check. So I'm a little concerned about that. That would be, I'm not paying a bill that drops in out of the sky and, you know, without some serious investigation. But that's what happened over the 2 days. So let's talk about the ultimate impact. Let's assume that the judge decides there was some misrepresentation, negligent, maybe more. What's going to happen? I think we both agree that the Sixth Amendment and other considerations prevent calendar considerations, among others, prevent the removal of Alan Jackson from the case. Can we agree with that?
I think so. Right.
Okay. So then let's just talk other sanctions. And I know that Brennan kind of waffled back and forth. He suggested that Alessi was trying to mix Rule 14 violations with the rules of professional conduct. That's 3.381. They both allow for sanctions, but it's just a different remedy, and it's tough to cross those streams. You really have to go one way or the other. Those sanctions could include, you know, slap on the wrist, don't do it again. You know, how many times we heard those? It could be monetary sanctions. It could be evidentiary sanctions, where she could prevent all or part of these witnesses from testifying. Again, unlikely. Or you could have the ultimate termination sanctions. And I don't think that's happening either. So right. I would bet
I think you and I both agree on that.
I would bet on a slap on the wrist, a warning that I'm watching you. You know, let's not even raise these questions in the future. Let's have a clean fight. You know, if you're Mills Lane, let's get it on. The guy in the, you know, he's refereeing the boxing matches. Let's have a clean fight. Okay, I've seen what's going on here, and it's not clear enough that I can punish anybody, but I'm watching.
Yeah. And by the way, I remind everyone too that remember after the other trial, again the prosecution came out and said immediately they were retrying her. So if I'm getting a bill from my main independent experts who were hired by the federal government, I really think the case turned upon, right? You know, if that's your evaluation because they supported the 2 medical examiners, I'm paying that bill right away too. Okay.
Yep. I get that. Let's get back to my thought about, you know, result-oriented billing. I get it. I understand that, but it's still it just isn't as clean as it could be. So let's talk about. There was also related to the payment. There was this question about from Brennan, the expectation of payment, right? That somehow, you know, makes it look like, well, they're less independent because they want to get paid, right? So they want to do what leads to them getting paid. And so he just leaves that thought hanging that maybe their testimony was somehow structured with the end game being, we want to get paid.
And of course, when they're asked, these guys are going to be professional. I'm sure they're going to say to the effect, look, I work for a business. They billed. I don't have any. I just like we billed the federal government and they paid us. We did our work. We were paid for our time. We're paid for our expertise. And I don't even know about the defense. I had no axe to grind. I had nothing. I was asked to do this, and that's what we did. We did this, and we came and told you about it because we were required to come and told you about it by a subpoena, you know, or whatever, you know. And quite frankly, our work doesn't change on who, you know, we were hired by the government. Usually when we're hired by the government, we're expected to confirm a prosecution, not say there should be no prosecution, you know. So, I mean, I can see them doing that to the jury too.
Yeah, and the question Brennan brought up, and it's, you know, the horse has left this barn. He said, you know, these disclosures should have been made before the first trial, or at the very least before any of the questions arose in that trial about the propriety of that interest between the defense and these experts. And it really trickled out and became, you know, the invoice, remember, was after the trial ended. And so he suggested, look, we wanted to be able to examine that bias. That's bias that we could have examined on cross, that this jury in the first trial would have heard about. Who knows? Could have affected the case. Okay, well, let's assume all that's true, just for fun. So what? You're getting a second trial. You know,
right.
It's not like it's over. You got to. What would be the remedy otherwise? Well, new trial maybe if the you know, chips fell as they needed to. But the bottom line is, you're getting a second trial. So bitch all you want about this. If it happened as you suggest, we're going round 2.
Yeah. So they're getting a second trial. The only thing that's different now is that the jury pool has heard all this, and I truly think that it affects Karen Reed badly, not badly, but it affects her in the sense that the jury pool is going to hear all this. And, just like people always, when somebody is charged with something, they always assume you're guilty, or some people, when you get not guilty, even people who are wrongfully convicted and there have been convictions overturned, there's a whole group of percentage that still believes they're guilty. And then you put this cloud under her right now just before jury selection. I think the prosecution achieved what they wanted to.
No doubt that anytime you can, there's a stink, there's a stink in the air. And anytime you can do that to muddy the waters, I think one of the words, I think I wrote it down here, was it mushy or was it?
Murky.
Murky, there you go. It's murky. That doesn't help the defense anytime you create a murkiness. And so we'll see what happens next week with some more traditional motions that are going to be heard. We'll come back to that.
Do you remember what those are, Michael? Because you're going to be back for that. I know you got to get on the road.
I know I can't remember the specifics, but they're mostly traditional discovery motions. I think there's something having to do with more video. Remember, there was an effort to resurrect the video from the Sally Port that was missing, and then it was not missing, and then apparently some officer who's now retired made a copy of it. So I'm not sure that has been turned over yet, and so we can see, speaking of ghosts, who knows what's going to show up on any videos of that Sally Port, whether inverted or not, right?
Right.
I mean, that could be, who knows what. And speaking of, misconduct, I mean, all of this, even if 100% true, pales in comparison to the inverted video. It's just not even a close call.
Right. You're absolutely. But here we are, and here you are, who have drove up for 3 hours today to get there. Has to drive back 3 hours to cover this case. But any other final thoughts before we announce what's happening tomorrow night?
Checking my chicken scratchings here to see if there's anything else that I thought was noteworthy. I asked, like I said, Alan Jackson didn't answer anything, but I asked a few questions like, so how do you think the court's going to respond? And then I said, what's the remedy? Now, if I ask somebody what's the remedy, that assumes there's going to be a finding of wrongdoing, right? So he wasn't responsive to any of those questions, and I was surprised to see such a buttoned up departure by the defense counsel, because compared to normal departures, pretty chatty. So I think that's a sense. I'll leave you with this: that they're taking this seriously, however it ends.
Right, and it should be taken seriously, because whatever it is, right or wrong, Brennan put it out there. Whether there's 10 misrepresentations or not, it's now out there. I have full faith the defense team did not do anything wrong, that this is not a violation of any ethics. If there is one thing they didn't turn over, I think Alessi has it right, maybe a violation of discovery by not turning over that list. But some experts send you a list of questions he wants. I mean, quite frankly, you may not even print them out. All right?
So I think what we know for sure is that when the second appearance by these witnesses occurs in trial 2, they're going to have a lot more on cross-examination to play with. There's no doubt about that.
No doubt about that. So, Michael Bryant, I want you to get back on the road. I should announce what's happening tomorrow night, though, before we say goodbye.
Yes.
Tomorrow night, you're going to be in trial all day tomorrow. So I will be hosting at 6 p.m. Eastern Standard Time with a co-host, Neil Rockweiler.
The Rockweiler will be there. He's a great guy. And I'm sure you guys will have some fun.
Yeah, well, we're going to do Karen Reed. We're going to do a brand new article that just came out on John Lewin. The headline of it. The headline. Let me just tell you the headline of it, so you want to all come back to watch.
Let's see. Was he elected Man of the Year? Was that what it was?
I don't think in this
Lawyer
article
Magazine
he
Man
was.
of the Month? No?
It was, and you can all get it. I don't know if we've tweeted it out yet or not. It's from the current. Hold on a second. I have
what's
current report.
What's the log line?
Disgraced yet still employed prosecutor John Lewin's ASAP Rocky trial meltdown becomes District Attorney Nathan Huckman's first major media disaster.
Oh,
so we're going to be discussing.
That's a mess. Just that headline is a mess. Yeah, you guys will have fun with that.
We're discussing that, and then we're going to answer all the questions from our viewers who they asked Monday night in our case of the week. Remember, we had the persons of the week with a jury from last week, and then we did about 9 different cases. And all the questions you ask will be answered tomorrow night by Neil and myself while you are working as a lawyer tomorrow night.
That's right. Well, I got do a little work here and there before we get back to play.
Yeah,
But
and maybe we'll
Thursday.
get to
Who knows what we got going on?
Yeah, maybe we'll get to Yak Gotti tomorrow night. Let's put him on the list too, Dizzy, because he has a hearing tomorrow too. So let's add him.
Oh, does he finally has his hearing tomorrow?
Yeah,
Okay, good.
Dizzy and Missy, let's add him to the list tomorrow that I gave you for tomorrow night with Neil. So with that being said, Michael Bryant.
All right. Until next time, try to do the right thing.
And with Michael Bryant, I'm Linda Kenney Baden. Together we are Justice Served TV. Please hit that like button. Subscribe. Doesn't cost you anything. Share and also hit that notify button. And we will see, or at least I will see you tomorrow night at 6 p.m. Eastern Standard Time.